During pendency of the appeal, respondent create disturbance and going to start the permanent construction. Your lordships एई सप्ताह आसी ପାଇଁ କହିଥିଲେ आसी construction कर दोचंती already IB file करछि
Tired of Belgium.
tomorrow आगे आसी
Tired of Belgium matter.
दियंत एई सप्ताह आसी देखिबा
Parliament is in that RSA which was heard and judgment was reserved.
Yes.
That,
Filing a note.
95 of 18.
You are filing a note.
A short note. I had filed earlier. It's just an additional
Yes.
brief note and that judgment of the previous RSA of this
Yes.
Honorable Court.
Okay.
Matter RSA 174 24 part and matter. Adjourned to this week. It has not been listed.
It will come in the supplementary list.
Pardon, Miller, in that matter, your lordship has formulated substantial question of law. That order may be uploaded so
Yes.
that we'll have an update.
Yes. See, RSA is the key need la. Aro sombar दिन दीपक हाँ ये कहीं तक करने आज मौका खाना तो अपलोड कर दो साइंस हाँ अब तो supplementary list आना
Pardon to make a mention, ma'am.
yes it will come tomorrow. It will come tomorrow in the supplementary list.
TRP से fresh material.
Yes.
item number 1 election petition
There is for
The dispute in this case relates to 12 Raurkela Assembly constituencies. On 22nd, 7, 24, your lordship has already admitted number 2 of 24 filed by Dilip Kumar Rai.
against the same respondent. Well admitted okay.
Miller?
Well highly admitted okay.
Miller. Now, on 23 also another EP has been filed, EP number 1 of 24. That is also with respect to 12 Raurkela. Both the cases are returnable to 27-8. So this case may be admitted and returnable to
7-8 today.
Well,
You will have to take notice by then you will have to take notice by speed post.
both ways जाओ हमें special
both ways हबनी आगे इतने कम दिन भीतर both ways हबनी
special messenger cost दो
special messenger देते हैं और both ways कहीं करें special messenger तो ना बस special messenger ना बे all right. Let's say Vidyadhar Mr. Leonard Senior Counsel
गोटाए दिन को रही गले सब गुड़ाक it will be easier for your lordship to
with Sri T.K. Biswal na with Sri T.K. Biswal and the petitioners admit issue summons fixing issue summons by special messenger, the cost of which shall be assessed and deposit be made by tomorrow.
Yes.
By tomorrow. Because 27 तारीख को summons such summons shall be issued for filing of written statement and settlement of issues. Place this 7th August.
item number 2 fresh admission
So before ballot is the husband ballot. We prayed for transfer of the 2 GR cases and 1 DB miss case from JMFC Bisham Kotak ballot to Barampur ballot.
TRP criminal 59 of 2024.
Ballot.
This case is 59 of 2024.
Ballot. 59 of 2024
But this is from you want it to be transferred from Bisham Kotak to
Barampur.
Barampur. And the lady is residing at Rayagada.
Rayagada ballot.
So how
He's serving ballot at there and lodging one after another. There are 3 cases ballot. And when I am going there ballot to attend the court, ଧମକ ଦଉଛି ଆଗେ ଆସୁନି କି କରନି ବୋଲି ତା ପାଇଁ ବୋଧେ ଏଫଆଇଆର ବୋଧେ ଦିଆଯାଇଛି that is annexure in 2023 ballot annexure 4
ଏଫଆଇଆର ତ ଦେଇଛନ୍ତି ତେଣୁ ବ୍ୟସ୍ତ କଣ ହବନି
ଯାଇପାରୁନି ଆଜ୍ଞା ତାପରେ ବି କୌଣସି तीन तीन टा केस
No.
ये सरकारी चाकरी कर सेठी belongs to जाजपुर I belong to Noyagढ़
Maybe, but she is at Rayagada. How can she travel to Burnapur? It will be highly inconvenient.
other than that court my lord
Ah.
hereby any court my lord
I'll permit you to move the court for protection if so advised. PRPCRL number 15. There is an application for transfer filed by the husband.
there are 3 cases my lord 3 cases
Easy. You go to application.
court application
3 cases came through.
गोटे कोर्ट रे दिटे तीनटा ही केस गोटे कोर्ट रे
No, no. You want transfer of which case?
मतलब two
Yeah,
GR
if-
cases and one
So how is it maintainable? How will it be maintainable? Individual case file करो तो. Maintainable केमती हो? मोइले गोटे केस अपना करछन.
तीनटा कर
GR case ना होने.
गोटे कन्फाइड कर
Let's just matter next week. So you file whatever
माल
you want to file, you file. You file 2 other applications,
माल
and in this case, you confine it to only 1 case.
यस
Or you may not file anything because I'm not going to allow the transfer.
ओके मिडिल जागा को जानु
किसी middle stage आगे ठीक है. Yes, Mr. Devedi, quick.
I do not agree. It is like the wife. She instituted a process of the CRPC at Borgad while she was staying on rent. And now she is residing in her parental house. She is seeking transfer of that case from Borgad to Sambalpur.
No.
Because
145 proceeding, why?
no, 125 maintenance case I am not
125.
getting. I am not getting since 2017 I have separated. I am not getting a single pie. Unable to travel to conduct at Borgad.
Alright.
It is now
Take notice, issue notice.
stay.
Stay करो. Notice of stay, huh? Date को fix कर दो. 23rd September.
I don't know post,
Alright, pass over.
I don't know 5,
Transfer of a case from Talcher to Bhubaneswar. I have filed the IA which has not been listed as last week.
अच्छी 236 of 2024.
Yes,
It is there on record. You want it to be transferred from Parcher to?
Bhubaneswar.
Alright, notice, stay. 23rd September. 23rd September.
Okay.
I don't know 6.
Please, your lordship.
The transport petition is there, transfer of MAT case number 83 of 2020 from London Family Judge Bolgot to London Civil Judge, Senior Division, Kondavanji. Sir, my lord, opposite party filed the opposite party filed case against against his wife under section 13 of Hindu Marriage Act on 1/7/2024. After that, his wife filed a FIR in Kondavanji police station. Then after the wife is filed a petition under section 12 of protection of women of domestic violence acts. Here, my lord, both are love with each other, and after that they were Hindu Marriage Act, and after that they dispute with each other, and his wife come to Kondavanji because her parents were not supported to her.
Why do you want the case to be transferred? Tell me.
My lord, the distance between the Kondavanji to Bargad is 170 kilometer around, my lord, and the wife is alone at her home. That's why, my lord, they
Alright, take notice.
stay the
Notice,
further proceeding.
notice stay. Yes, 23rd September.
I
Will
don't
I
know
should-
7.
May I please, your lordship? Well, in this case, the petitioner has approached for transfer of civil proceeding number 142 of 2024 from the court of the Judge Family Court Jajpur to the court of the Judge Family Court Cuttack, my lord.
Alright, notice, stay, 23rd September.
Oblige, my lord.
I don't know 8.
Chief Justice को endorsement हो चाहिए.
may I please your honor my lord annexure 4 my lord 5
Just-
by virtue of
Just-
police of
This matter was specifically assigned to this court.
Earlier it was listed before Honorable Justice A.K. Mahapatra.
There
At
was
that time,
no, before
this-
Justice Mahapatra, you were the petitioner.
my lord
So you made a submission that this matter is specially assigned to the court of this court.
No, my lord.
I mentioned, ma'am.
You mentioned.
No, I mentioned that the matter is assigned to Honorable Justice, your lordship. ma'am.
No, this is what matter?
গাঁ সাথী
Engagement under scheme,
গাঁ সাথীটা তাহলে হবো আমরা হবো নাই?
my lord.
So probably I mean, wanted to mention something else.
একে মহাপাত্র
No, no. He probably wanted to mention that the subject matter is assigned to you, not this matter.
minor
That is why it had to go to the Chief Justice. So this is a গাঁ সাথী matter.
গাঁ সাথী
All right. So this was decided that it will be disposed of finally at this stage. All right. What is the matter? Tell me.
My lord, annexure
Or particularly
For page 20.
Village matter.
5. I have been a
Page?
petitioner has been selected in Grama Sabha to be engaged. And the opposite party was earlier engaged, but he has from 2017, 2021, he has been disengaged. Thereafter, Police Sabha has selected me and issued for engagement to BDO, send selection letter. But I could not have been selected because thereafter the earlier villagement has moved to this honorable court, and this honorable court has passed and pleased to pass an order of stay. So
That matter is also here.
yeah second is the petition.
So you are in that order, you are challenging the disengagement.
Yes, I am challenging the disengagement order.
Yes.
my lord, there
And I have prayed that collector may consider my grievance and
they have only
Allow me to
filed a
continue.
repentation before collector and moved
So that's all.
for disposal of the repentation as per law. During
So you see, what has happened is, either way, if an order of disengagement is now subject to scrutiny, either by way of a challenge before this court or any other forum, or by filing a representation, it is the same thing.
my
It is open to scrutiny. So what I think it's better to remit the matter to the collector, both cases. So your appointment depends on his the validity of his engagement order, disengagement order.
my
If he succeeds, then you go.
my lord.
If he does not succeed, then you come and.
Yes, my lord.
Yes, and you are appearing for?
I am appearing in the second case. I am appearing for the Sarpanch, opposite party number 3, my lord.
Yes,
As per the comprehensive guideline, my lord. That is.
Sarpanch is the appointing authority.
Yes, my lord. The video is the authority, my lord, in the selection procedure, my lord. As per the government guideline, my lord. The present petitioner in the second case, my lord, he was found disqualified because of his overage, my lord. And
Whatever.
Yes.
Will not pass any order.
As per guideline, I am eligible.
This court will,
Petitioner in.
you are appearing for the Sarpanch in the second case,
yes, my lord.
in Mr. Panda's case.
Yes, my lord.
So this court will not pass any order on touching the merits of the case. This court will simply direct whoever is the authority, either the collector or the BDO,
Video is
to look into the demands of this petitioner
Video is the authority.
and to pass an order afresh.
My-
As I have said, the case of this petitioner will depend on the result of that
Yes, ma'am.
disposal of the representation.
My lord.
and both must be heard. All the.
When it's a question of, I mean, the validity of the disengagement order, so he doesn't have any right of hearing.
Yes. So far as only.
How does he come into the picture?
Yes. So far as
supposing-
engagement is concerned, she is the only.
Supposing the disengagement order is set aside, the collector finds that or whoever is the authority finds that the disengagement order is invalid.
No.
Then
prejudice
whatever
to anybody.
subsequent action has been taken by the Grama Sabha or the Police Sabha, whatever, it becomes redundant.
Yes.
Correct?
In the second case, there was a direction to file a compliance affidavit. That compliance affidavit has been filed by the secretary.
In the second
The
case,
hard copy of the compliance affidavit may find.
what sort of program they have conducted for capacity building of the female survivors?
Second.
Why was this order passed?
Judicial notice was taken of the problem, my lord, the interference of the husband of the woman Sarpanch, my lord. But in the particular case, there is no interference, there is no material on record to substantiate the allegation made against the husband of the Sarpanch, my lord. But this learned court, before issuing notice, has taken a judicial notice of the general problem, my lord, to stop the Sarpanch Pati, my lord, or Paksi Sarpanch, my lord.
Oh.
But- and has directed the government to take steps to stop the interference of the Sarpanch Pati.
How is it relevant for this case?
No, that is not relevant. That is general order, my lord, passed. So far as this case is concerned, my lord, it is not relevant.
As directed by order dated 5/12/2020, there is a second case. Learned AGA files a compliance, files an affidavit of compliance stating in detail the steps taken of the female sarpanches of the state. The compliance affidavit will be kept on record. Dita writ application both these writ applications being collected are heard and disposed of, are heard together and are being disposed of by this common order. Charter specially order the petitioner in WPC number 8051 of 2024, namely Raghu Mangaraj, it claims to have been selected for engagement as village mate by the Police Sabha na Gram Sabha? By the Police Sabha of Chhapriya Gram Panchayat. Chhapriya Gram Panchayat. Yes?
Under Golamunda block.
Under Golamunda block of Q district.
Kalahandi.
Of Kalahandi district.
Where the
Just-
petitioner score was also participated.
Just. It is his grievance that despite favorable recommendation, he has not yet been favored with an order of engagement. Stop. Insofar as the petitioner in WPC number 31039 of 2023, namely Manoj Kumar Mangaraj is concerned, he was engaged as Gramasathi since
2017, 2020.
2017. Stop. For some reasons, for certain reasons, he was engaged in the year 2021. Challenging such order of disengagement, he has approached this court with challenging such a disengagement.
High recommendation before police.
Being aggrieved by such order of disengagement, said Manoj Kumar Mangaraj approached the collector Kalahandi by submitting a representation.
Annexed 2 of that.
He filed the present writ application as no order was passed on such a representation. As it appears, the petitioner in WPC number 8051 of 2024, Raghu Mangaraj, was recommended for engagement as village mate. Vacancy created due to disengagement of, what is your name? Manoj Kumar Mangaraj. The petitioner in WPC number 31039 of 2020. It is borne out from the matter. It is borne out from records that he has approached the collector Kalahandi against such disengagement. Such representation is still pending. Obviously, the claim of Raghu Mangaraj can only be considered after disposal of the representation of Manoj Kumar Mangaraj. Therefore, without expressing any opinion on the merits of the claim petitioners, the writ applications are disposed of, directing the collector Kalahandi to first consider the representation submitted by Manoj Kumar Mangaraj against the order of disengagement in accordance with law within a period of 2 months from the date of production of certified copy of this order by the petitioner. Stop. Further, the collector finds no merit in the representation so submitted, comma, necessary orders shall be passed on the recommendation made by the Grama Sabha in favor of Police Sabha in favor of Raghu Mangaraj without any further delay. That's all.
Urgent set.
Urgent copy.
Since I am continuing, I may be permitted to continue.
It is, since it is,
My lord, he has stated in the petition, he
The stay is there, stay what?
stayed due to stay, he has not.
I am continuing.
all right.
He has been disengaged.
Sri
as per
Ponda
the
Learned
DGP
Council,
petition.
all right. Sri Ponda Learned Council for the petitioner Manoj Kumar Mangaraj submits that despite being disengaged, his client is continuing as village mate on the strength of interim order passed by this court. Stop. If such is the case, comma, he shall be allowed to continue till disposal of the representation by the collector.
Time limit.
Within 2 months.
No, 9.
May I please your lordship? My lord, in this case, the state is supposed to file the counter affidavit.
The query was made. In compliance of that query, the affidavit is being filed.
Now, then,
Yes.
the other person was disengaged.
Yes.
As directed, learned AGA has obtained instructions and files an affidavit in court. Have you served copy?
No, my lord.
Let a copy of this affidavit. No, the affidavit be kept on record. Let a copy thereof be served upon learned counsel for the petitioner. List this matter next week. No.
Appellate.
Item number 10.
May please your lord. On behalf of Mr. Swain, kindly permitted to. My lord, the petitioner who are working as a level B teachers filed the writ application.
Oh, this is a Dhananjay Sharan Day.
Yes, my lord. Your lordship has already been. I have given the 3 matters are same.
About a
Again,
individual representations. No.
individual reference.
Yes.
Public.
Item number 11.
Here in this matter, my lord, I'm extremely sorry that I am filing an additional affidavit today in response to that reply affidavit which my young friend had filed the other day. All right. Because that was directed on the reply affidavit to the rejoinder affidavit that was filed as per your lordship's direction. Because in one of the paragraphs of the rejoinder, I indicated that 4 persons similarly situated, they could be regularized. My lord wanted that let them file an affidavit with documents in support of that. So that they said that my appointment is 89 days with breaks, but those 3 who could be regularized, their appointment was dissimilar. And again, what they said about the 4th person, where I said that she was overaged but regularized.
Anyway, you file an affidavit today, let him take instruction.
Yes, I have
Das.
included also the documents.
Sri S.K. Das, the petitioner files a further affidavit. What is it?
Additional affidavit
Additional affidavit.
in response to the reply to the
In response to the reply filed by the CGC to the rejoinder filed by him earlier. Stop. The affidavit be kept on record. Copy of such affidavit has been served upon Sri Maharana Leonard CGC, who wants some time to go through the same and to make his submissions thereon. List this matter next week.
2 weeks out. To say.
And you'll get the bar. Then we could do.
Who unescorted?
27th August. 27th August karo nahi da follow. Second September.
ଏତେ
ମଝିରେ 2 week କଣ? 2nd September ସରିଯିବ।
ଏଇ ମାସରେ ଥାଉ
All right, 27th,
because of
27th August.
it has already been completely hard.
I do not 12.
On behalf of Mr. Mishra, kindly taken the matter after 2 days. This is sought for the instruction and the petitioner is unable to come to the due to the illness.
As requested by learned counsel to the petitioner, list this matter next week.
I do not 13.
Please, my lord. My lord, last occasion, my lord also.
13th ଆପଣ କରୁନ କଣ କରିବା
RSA 105/21.
WBC ର
Regular concepts.
ସକାଳ ଓଳି ଆମେ ରିଡ୍ ଉପର ଓଳିକୁ ଆମେ ସିଭିଲ ମଝିରେ କ୍ରିମିନାଲ ହେଲା କେତେବେଳେ କେମିତି ଟ୍ରାନ୍ସଫର ତେଣୁ ସମୟ ଅନୁସାରେ ଆପଣ ଜାଣିବେ ନା କୋର୍ଟରେ କଣ ଚାଲିଛି ଆଉ
My lord, before my lord senior will proceed with the case, my lord. On the last occasion, after going through the detailed documents, this is a matter relating to recruitment of ACBC category.
Did you go through the judgment?
My lord. So this is relating to the recruitment to the post of Sikya Sahib against category. And our stand is that, my lord, these special reserve categories, that is the PH categories and the sports person, my lord, they have conflict of interest. So taking into consideration the list which you had produced, my lord, the lordship calculated that the one post from the PH category is in excess and one post from, sorry, 2 posts from sports person, my lord, that is in excess. No, your lordship had pointed out, my lord.
No, but
That
I
previous order
made some
itself,
calculation actually.
Previous order itself, my lord, your lordship pointed out.
The total posts be 3% for physically handicapped and 1% for sports quota are to be applied to this figure 124. Jahala.
So, my lord, I took the instruction. I got that instruction in from OSHEPA first. But I wanted, because we are relying upon the government notifications to that extent. So I need only 1 to 2 days, my lord, for filing in shape of an affidavit. My lord, but before that, my lord, I can clarify that. Previously, my lord, that was in 1989 resolution, my lord, that with respect to this allotment of ex-military service, sports person, and later to that, my lord, in 1995, PWD Act came into force. On the basis of that, my lord, one resolution came. There also, my lord, it was 3%. But after the PWD Act 2016 came, my lord, government issued a further notification on the basis of the Act itself, that now it is 4% reserved. Reservation is 4%. And
when was that notification issue?
2016 last, my lord, 2017 first.
No, but was this...
before this election process, my lord. Before this election.
All right.
And my lord, the advertisement says that whatever the government guidelines relating to the PWDs, my lord, that is there, that is to be followed.
All right, let us accept 4%. 4% ହେଲେ କେତେ ହଉଛି?
That I propose to.
1% sports quota ଅଛି. Sports quota ତା ବଢି ନାହିଁ.
Sports quota body. Sports quota ର sir ସେଟା ଆରଥରକର ଯୋଉଟା fill up ନ ହେଇ ପାରିଥିଲା ସେଟାକୁ ଇଏ ଫରୱାର୍ଡ କରାଯାଇଛି.
କେମିତି ସେଇଟା ତ
ମୁଁ ସେଇ ଦିଟା ଯାକର ନୋଟିଫିକେସନ
ସେଇଟା ଭୁଲ ହେଇଛି.
sir notification ଦିଟା
ଫୁଲ ଆପଣ ହେଲେ ସ୍ପେଶାଲ କ୍ୟାଟେଗୋରୀ ଗୁଡା ନେକ୍ସଟ ଇୟରକୁ ଯିବ.
ତାଙ୍କର ରୋଲ ଓଭର ହବ.
ନାଇଁ
ମୁଁ ମୁଁ ଯେହେତୁ I am relying upon notifications.
I may be unaware. I don't know, but
today
this social category,
yes,
will be carried not this special category.
Yes, sir. I have
horizontal reservation is a
there are provisions, my lord.
Yes.
There are provisions, and they had relied upon, and accordingly they have selected. That is what, my lord, I am going to show it before lordship. This matter will be taken up next week, my lord. Within this week, I will hand over a copy of the affidavit, my lordship.
The SN Patnaik Leonard AGA undertakes to file counter affidavit in course of this week.
Yes.
And requests for adjournment on such ground. Let's this matter next week.
Yes.
Counter. Can it be filed in the meantime, positively?
And let the pattern may remain continue.
Pattern it will come as pattern.
Item number 14,
Pass over.
item number 15,
Pass over.
item number 16,
Item 16, this case may be the file in OJC number 7201/1994 and OJC 2930/1992 may be listed along with the report.
They are relevant.
Yes, sir.
My lord, in this case, I am appearing for the OP number 3. Now this case is not maintainable here because as per the section 24C, within 60 days, they have prepared an appeal before this honorable court. They are challenging the order of the education tribunal. My lord, come to the
My lord, in case of
number 2. Number 2, the managing committee challenging this order. That time there is no valid managing committee. How the order was challenged in outsider? I am succeeded the case. Now I am retired. I am not getting any pension or any area salary. I am not getting my salary, my lord. So, my lord and senior, there are 2 cases that has come to the honorable court.
So tell me how is it relevant then?
My lord, if the order passed in a GI case is under challenge, their appeal FAO is maintained.
No. How are the other 2 cases which you are asking to be called for? How are they relevant to this case?
My
What
lord,
is your prayer in this case?
my lord, out of the opposite party number 3, this opposite party number 3 has annexed the copy of order passed in 7/20/1994 in his counter affidavit. That is annexure D/3, page 17.
Here you are challenging the order of the appellate of the education tribunal.
Education tribunal.
I think FAO lies.
My lord,
FAO lies probably.
24C, my lord.
no,
FAO.
Yes, my lord.
my lord, if the order passed in a GIA case, their FAO is maintainable. If the order there, in that case, writ petition is maintainable.
Yes,
This is the regular procedure of the honorable court.
This is an order against 10A.
Termination.
Termination.
Termination, my lord.
Yes.
So writ petition is maintainable, not FAO.
I think this has been settled, well settled.
Yes, my lord.
देखिए कोर्ट का order for
Okay. Service of teacher who aided institution not to be terminated with their approval. They have not taken any approval to the director. They have simply terminated my service. When I have filed a GI case in way back in the year 2008, they disclosed your service is terminated. Then I have filed under section 10A. I have succeeded. After succeeded, they have not complied this order. I have filed the execution case. After the execution case, they filed a writ application before this honorable court. Well, kindly come to the 24C.
Or not?
Okay. Appeal to High Court. Any person aggrieved by an order or decision of the tribunal may prepare an appeal before the High Court within a period of 60 days from the date of such order of decision of the judgment. This is an appeal.
The appeal in case of the application filed on 24B, but not on.
I have
No, not on filed this writ petition, which I am referring. By the writ petition, the honorable court direct.
We'll do one thing. Let us call for all these, both the disposed of applications. Let us hear it together on one particular day.
No,
we'll take it up.
Yes, my lord. Well, fix a short date, my lord.
2011 ରୁ ଆପଣ ଧୈର୍ଯ୍ୟ ଧରି ବସିଛନ୍ତି ନା ଆଉ
ମେମୋ ଦେଇଛୁ ଜମା କେସ୍ ଆସୁନଥିଲା
2011 ରୁ ଆପଣ
ଆପଣ ଦେଖନ୍ତୁ କେତେ ମେମୋ ଦେଇଛି
ତଥାପି କେତେ କଣ ହବ
20ଟା 30ଟା
20-30ଟା ମାତ୍ର ଦେଇଛନ୍ତି ଆଉ କଣ
କରିବୁ
20-30ଟା
କହିବେ ଯେ ଏଇଟା ମାନେ ହିୟରିଂ ଆମେ ନବୁନୁ ଆଉ ଆପଣ ନଉଛନ୍ତି
My lord, OJC number 7201 of 1994.
लिखी की दे दियो. Let's this matter next week along with Swanson.
My lord, one week after 27th रासु.
27th रे बहुत matter होगा. 20th.
28th.
Yes. कोड़ी. हेले. Please come ready.
My lord, 28th.
कोड़ी. 20th.
I do not 17.
You get the cards.
It's not like after launch. I result or appealed in this case.
No, not after that.
Written submission are already ready with the written submission. Written note of argument. Only after let it after launch. Thank you. For the first case, I don't.
Let's this matter tomorrow. Not after lunch. After lunch, I have a different matter. So
Today I will for the copy.
Item number 18.
My lord, conducting counsel is ill. So
who is the
please,
conducting counsel?
Ajit Kumar Pandey. On behalf of SK Mahab. Next week, yes.
2013 matter. What is this matter?
It was ordered of amendment.
Because
Amendment.
prayer he has made that she to be
Amendment application. If any. Where is your amendment application?
I'll in next week, yes.
hello.
Planning for next week. Okay. Is this matter next week as per for the land count?
Item number 19.
19 minutes pray for next week, man.
The 2013 matter. Counter affidavit.
Counter
No
be
counter
there
affidavit is required.
All right. This is matter
Order
next week.
passed in appeal is under challenge.
All right. Let's this matter next week as per.
Item number 20.
It's embarrassing on my part to pray for an adjournment, but the written instructions have come. But I would like to clarify it before I convince your lordship. The affidavit that the petitioner had filed as regards some other similarly placed persons having been granted that I have not got. I'll be talking to the registrar. Let it come on next week, 20th.
Who's for the petitioner?
I am.
All right. If he wants to file an action. Sri Tarananda Patnaik Learned Council appearing for the university.
My lords.
The university requests for a short adjournment on the ground that he has, though he has received the parawise comments,
My lords.
yet he requires some further, he has sought for some further instructions. Expects to receive in course of this week. Let's this matter next week. Affidavit, if any, be filed positively in the meantime. Next week, next, mana 40 tarikh asbo.
Item 21.
May I please your lordship? My lord, in this case, the petitioner was the head quantity of the toll. With his requisite qualification, he has a
No, on the last occasion, this matter was before Justice Nursing.
again.
You say that this has already been decided in some judgment of this court.
I will.
Head Pandit is at par with headmaster.
Again,
This is your claim?
my lord,
So are you relying upon any judgment?
my lord.
This has already been decided.
My lord, only the fact is already I retired, but my scale of pay is differentiated from the headmaster and the head pandit of the toll. And in this decision, I have submitted that there is no clarity. The headmaster of the secondary school and head pandit of the Madhyama school.
No.
Only.
This judgment, sir, this judgment relies upon Rule 9 of the 91 rules,
Again.
which talks about parity.
Again.
So first it has to be shown that headmaster is the same as head pandit.
My lord.
That you have
My
shown.
lord. Annexure.
No, it's a no, it's a point. No, that out.
My lord, page 14, annexure 3. This is the staff pattern of the toll.
My lord, Madhyama is equivalent to high school standard, secondary standard, and it requires the head pandit, Acharya head pandit, Shastri pandit, BABD 1, and IACT 1. These are the staffing pattern of the school. Now I am the regularized and my salary may be equal with the salary of the headmaster because the course is same as per page 16. Examination is conducted by the Board of Secondary Education. Everything is equal and my post is equal to the post
Come to
of...
page 16.
Yes.
The board has recognized the Madhyama examination conducted by Sri Jagannath Sanskrit Sri Vihar Puri as equivalent to HSC examination 1980.
Yes.
After inclusion of English, General Science and Mathematics subject of high school standard in the its syllabus prescribed for 83-84 in the first year of Madhyama class.
Yes,
Whether that has been, this is subject to this condition. That English, General Science and Mathematics must be included.
My lord.
Alright. We do not know what has happened.
My lord, I was getting the scale of trained graduate scale, but trained graduate BABD is subordinate to me. So my salary may be equal to the post of... My lord, this is my simple prayer. But
What is your counter?
My lord, lordship may come to the first page, last but one para, my lord.
First?
First page of my counter.
Yes, yes.
With respect to the last one para.
That is what I'm saying.
In this respect, it is submitted that the prevalent status of the sustained institution in respect of the staffing pattern of the government with its admissible scale of pay and role strength of the student, etc. Sorry, madam. It is the counter filed by opposite but no 3, my lord.
Open number 3
Last but one, my lord. In this respect.
Oh, in this respect, okay.
My lord, the para number 3, what the petitioner submitted, it starts with. Then the reply is this one, my lord. That these two institutions are different. And the next para, my lord, para number 5. And my lord, the second para is also relevant, my lord. Para number 5 and thereafter, my lord. That is submitted that since the pay of the petitioner has been fixed with the prevalent rules as admissible to the head pundits of institutions of the state, as per their status.
That is what I was asking, and you have answered it in paragraph, second paragraph, subparagraph of paragraph 6.
Para number 6 here.
Until and unless the status of head pundit of Madhyama Sanskrit institution.
Yes, madam.
So why was this application kept pending? It should have been disposed of directing the state government to take a decision in this regard. It kept it pending since 2014.
Para number 6. My lord, reply in para number 6 as well as reply in the last page of the.
So, sir, what now? You see, straight away, this court cannot issue a mandamus saying that you treat them as equal. So the government has to take a call on that. You have one thing in your favor is that the board has already must be equivalent to that what you call HSC examination, provided the other subjects are also included. Isn't it?
My lord, I was drawing the scale of a train.
No, I cannot pass that order. I can only direct the state government to take a decision within a limited period.
Yes.
That otherwise I cannot direct that. That's how the petitioner was initially appointed as an assistant pandit. Initially
I was just
assistant pandit,
and I have been promoted.
Durga Sanskrit Vidyalaya.
Again.
In the district of Balasore. When was that? Chirakebe?
On the basis of OJC order 5110 of 1994.
Kebe join kale kya? Kebe join kale?
1/4/98.
On 1/4/1998. By order dated 2/1.
Sorry, my lord. 1/8/94.
1/8/94. By order dated 2/1/1999 of the Director of Secondary Education, the petitioner was promoted to act as head pandit in the same toll TOL in the scale of pay of rupees.
My lord, may I be excused. Basing on the OJC number 5/1/1 by 1994.
Sir.
Again.
Sir, relevant कौन था?
ସେଥିରେ direction ହେଲା
কোন সেতরকু মিলিব আমার
ଆଜ୍ଞା
আমার কোন মিলিব সেতরে স্যার
ଆଜ୍ଞା
স্যার সে ହେଇଯାଇଛି ମୁଁ କଣ ସେଟା ବୁଝିଲେନି ସେଟା କଣ ଦରକାର ସେତିକି ମୁଁ କରିଦଉଛି
ଆଜ୍ଞା।
the scale of pay of rupees 1400 ରୁ 2600 as per rule 8(2) bracket small b of OE rules 1974 ये जो OE rules टा पूरा full form लिखो 1974 with effect from 1/8/84 the government in the erstwhile education department by notification dated 31/1/1992 decide that certain courses offered by the Sanskrit tolls shall be equivalent to different levels of regular schools. As such, institutions imparting education up to Madhyama level were held equivalent to secondary schools. Further, the Board of Secondary Education Orissa recognized education conducted by Sri Jagannath Sanskrit Vishwavidyalaya, Puri, as equivalent to HSC examination 1985, subject to fulfillment of certain conditions. The petitioner's grievance is that though he has been working as the Acharya head pandit of the toll which provides Madhyama education, he is to be treated at par with headmaster of the government schools, secondary schools. All right. As such, he claims the pay scale of the headmaster of secondary schools. Counter affidavit has been filed by the district education officer, inter alia, stating that until and unless the status of the head pandits of Madhyama Sanskrit institutions is made equivalent with that of headmasters, high schools in all respects by the government, the petitioner's claim cannot be considered. This being the stand taken, there is this court is of the considered view that no fruitful purpose would be served by keeping the writ application pending any further. So it would be prudent to dispose of the writ application, directing with a direction to the secretary. Will direct to the government or government? Directing the secretary to government in the Department of School and Mass Education, take a decision with regard to equivalence of the status of head pandit of Madhyama Sanskrit institutions with that of headmasters of secondary high schools. High schools. Secondary of the state. Let a decision in this regard be taken within 3 months from the date of communication of this order. By the State Council. The decision taken shall be intimated to the petitioner. All right. Let them decide, then we will see. Your good name, sir?
Sarachandra Samal.
I will like Sri Sarachandra Samal, the petitioner, and Sri S.N. Patang, DG for the state. Yes. Pending 2014 to I don't want admission stage. Sorry, 10 years we have kept it pending. It is our mistake, not yours. Sitting here, I am saying that.
On the last occasion also, my lord, it was to be disposed of, but my lord senior actually told that there are some decisions in this.
No,
regard.
he has referred to a judgment
Yes.
that is on the parity of 9.
Yes,
Rule 9.
yes.
That will not
That
apply.
will not
First, that parity, the status has to be equal.
Yes.
Then only that parity can be.
Item number 22.
Please, your lordship. Petitioners prayer to pay the salary from the date of reversion to date of reinstatement in service. From the date of reversion to date of reinstatement.
4/1/2012 from the date of reversion to date of reinstatement.
Minor. So, Annexure 1. The petition was promoted to the post of supervisor from the post of Anganwadi
Where
worker.
were you working?
My lord,
Anganwadi worker.
worker to promoted to supervisor.
Okay.
And
You are Sabita Vishwala.
my lord,
Yes.
serial number 8. So, while the petitioner was continuing, the annexure 2, the joining. Then annexure 3, the order of reversion was passed.
Annexure 3 is a show cause.
So cause.
Then
Annexure 3,
the
fourth.
it.
the pursuant to the above order, honorable promotion Sabita Vishwala appointment withdrawn. Withdrawn by virtue of this order of this honorable court. That order, that I have quoted that order at that page, my lord. Challenging that reversion, I have approached this honorable court. Para 6, para 10, page 6.
Yes. This order was challenged. The same order which you have just shown.
Yes.
That was challenged earlier.
Earlier it was quashed by this.
Let us see. Yes.
Page 8, the relevant portion, page 8. Then started the counter affidavit filed, my lord. The counter affidavit filed on behalf of the opposite 213, there is no indication giving any show cause or opportunity petitioner before her appointment order was withdrawn. It appears that due to the conduct of officer subordinate to the OP2, collector and district magistrate, Cuttack, interim order of this honorable court was not brought to the notice of the DPC was held. Instead of approaching this court seeking appropriate direction, opposite partner to collector and district magistrate has passed the improved order. It has been abhorred in para 8 to the counter affidavit that after discussing the matter with the State Council with regards to compliance of the improved order, the order of withdrawal was passed. Prima facie, the action of P2 is withdrawing appointment order unilaterally appears to be arbitrary and without sanction of law and principle of natural justice. Therefore, the interim status is not sustainable. Retribution allowed. Annexure 4 passed by the P2 collector district magistrate is quashed. Then I was reinstated in service under Annexure 5.
Annexure 5. No, Annexure 5 is your EA. Is your representation.
When I joined in service pursuant to the passing of that order, your Annexure 6 make no glance. There it has mentioned that subject to result of WPC 1614/2010. I am no way concerned to that. There's something others have challenged regarding promotion of other. The parties are there different. I am no way concerned. The lordship may kindly have the order of 160611210, my lord. So why the order of withdrawal of my promotion has been quashed unilaterally? There no rider was given. Then quoting some observation in that subject to outcome is not correct one.
It was said that one post shall not be filled up without leave of the
Yes,
court.
but that was in other DPC, not in this DPC. DPC in which I was promoted.
We will call that entire case that we will call for. What is your stand in the counter?
My lord, in fact, my lord, what now it has been presented by my lord, Mr. My lord, that it is an outcome of the other case, other decision, my lord. There was a direction with some interim protection, my lord.
Yes.
The dealing assistant, my lord, he did not place the same before the selection committee, as a result of which the persons were selected and they were offered with an appointment. Later on, my lord, when this particular order was placed before the authority, then they found that the last person, whoever has been selected, he is not to be given. In fact, my lord, the petitioner is the last person.
No. That is
But what it has been submitted in the council.
We'll do one thing. We'll let us call for the record of this case.
Yes, I am there.
We'll take it up, Mr. Mahanti, next week. No, next week. We'll take it up on 27th.
27. Yes, ma'am.
Release this matter on 27th August along with OJC WPC number 16012 of 2010.
Well, may we submit one thing, because I have been provided with the so I took the help of your lordship's file and I found that, my lord, already WPC number 16012 of 2010 is tagged with this. So this matter may taken up from 27 because I have to go through that, my lord. But I think, my lord, there is a previous judicial order to that effect.
Acha. Oh.
As a
This
result of which, my lord, the
matter,
file is very much available.
next week will on 27th will kar do.
On 27th,
What has it been disposed of?
No, that is pending.
that is pending.
The other DPC order was challenged, not the petition.
That we will find out whether that order, the prayer in that writ application, does it in any way affect?
Yes.
End of the matter.
Yes.
No, that petition is also with me. That is not.
देखिए अपन ट्रेस करिए वो गोटे टेबुलर चार्ट भलिया करी करतो सेथरे प्रेयर कोन एथरे प्रेयर
आगे
ये करतो सुविधा हो यस आइटम 23
Item 23. May I please? Lord, the Anganwadi worker, the order of dismissal that the basing on the same allegations that misappropriation of Anganwadi materials, two proceeding, a departmental proceeding was initiated, so also a criminal proceeding was initiated. So it was 2008. Thereafter, my lord, in a departmental proceeding, immediately he was removed from service. Against that, he preferred appeal. That will at annexure 14, page 65.
Yes.
In the appeal, it was confirmed and she is out of job. Now, my lord, so far the criminal case is concerned, the Lord trial court found her guilty, and in the appeal it has been reversed and she has been acquitted. Thereafter, I filed an application before the authorities for consider of my case in view. That was not considered. I approached this honorable court. This honorable court directed that to approach the competent authority. I filed an application before the sub-collector saying that since I have already been acquitted from the criminal case, so my case may be reconsidered. The Lords will get the impugned order at page 62, annexure 19. But my grievance has been rejected on the ground that since the appellate order is still subsisting, so the sub-collector cannot pass any order reversing or.
So will
Yes, sir. That is.
will direct the collector to take note of the subsequent development.
That is why.
ये 2016 ରୁ pending ଅଛି
Counter result.
ଆପଣଙ୍କୁ ମୁଁ ଦୋଷ ଦଉନି ମୁଁ ନିଜକୁ ଦୋଷ ଦଉଛି ଗୋଟେ ମିନିଟରେ ସରିଲା the previous writ application also you saw for 10 years you had kept it pending only to send it back again. One feels sorry sitting here I tell you one feels sorry, this is not justice. I'm just directing passing a very small order.
Yes, my lord.
The petitioner was working as an Anganwadi worker Indira Nagar AWC under Bethnoti ICTS project of Mayurbhanj district. She was disengaged on the allegation of committing misappropriation of misappropriation of certain commodity.
Following the orders of the
Misappropriation of certain commodity.
Yes.
She filed an appeal against such order of disengagement before the collector.
Yes, ma'am.
The collector, in his order dated 27/2009.
No, 19/2000.
ना सेटा communicate हिची मेमोरी किंतु ऊपरटा देखो order pronounced in the open court on 20 July 2009.
Yes, sir.
By order dated 20 July 2009. Dismissed the appeal, confirming thereby the order of disengagement. Stop. In the meantime, a criminal case was also instituted against the petitioner. Same allegations. Being GR case number 114 of 2008. Stop. In the said case, the petitioner was convicted for the offence under
For the 409.
section 409
IPC.
of IPC. So, the petitioner carried the matter in appeal to the Court of Sessions, which was heard and disposed of done at Additional Sessions Judge Baripada. Stop. By judgment passed on 31/10/2011, the order of conviction passed by the trial court was reversed, and the petitioner was acquitted of the charges. The petitioner thereafter approached this court in WPC number 14947 of 2009.
It's a ticket. Actually,
Confirm.
challenging the collector's order, my lord.
Hmm.
He support in WPC number 14947 of 2009. In between, my lord, the development during pendency, my lord, the development ticket khali change.
Challenging the order of rejection of his appeal by the collector, the petitioner approached this court in WPC number 14947 of 2009. By order dated 8/1/2016, this court, taking note of the fact that the criminal case against the petitioner had ended in acquittal, granted liberty to her to pursue the claim before the competent authority. Stop. Accordingly, the petitioner submitted representation before the sub-collector Baripada, bringing on record the order of acquittal passed by the criminal court. Stop. The sub-collector, by order dated 10/2/2016, rejected the representation on the ground that the order passed by the collector confirming the order of disengagement is still subsisting, is still in force. After hearing learned counsel for the petitioner and learned state counsel, this court finds that would be served by keeping this writ application pending any further. Stop. It would rather be prudent to permit the petitioner to approach the collector in a fresh representation, apprising him of the developments vis-a-vis the criminal case. Stop. So can he withdraw his order of appeal? That order has to be set aside.
Well, is not the subject matter of dispute, matter. I am making a submission.
This is a subsequent development.
That is what, my lord, I am submitting.
So how can I do
The
that?
previous writ petition was dismissed. As withdrawn. And my lord,
Granting him liberty to
granting
move
him- Liberty person was in the upper person, my lord, but he exercised the same one. And thereafter, my lord, he approved for the sub-collector. But once there will be a judicial order to that effect, without being influenced by the previous order, your lordship mentioned.
All right. So simply कर देले how? If such representation is filed, or shall we ask him to file a further appeal?
No,
If such
it's representation.
if such representation is submitted within 3 weeks from today, the collector shall consider the same and taking note and dispose of the same in accordance with law. The subsequent developments vis-a-vis the criminal case.
And without being influenced by the
Stop. Further, the collector shall not be influenced by the earlier order passed by him in
appeal.
rejecting the appeal filed by the petitioner.
That is dated 1/9/2009. That may be.
मेमोटा ही चाहिए 20 জুলাই দেখুন অর্ডার প্রোনাউন্সড ইন ওপেন কোর্টটা দেখুন
জুলাইটা কমিউনিকেট এইট লাইট
20 জুলাইটা হবো হ্যাঁ ইনফ্লুয়েন্স বাই হিজ প্রিভিয়াস অর্ডার 7/2009 ହେଲା
after giving a chance of personal hearing also Malay, that may be.
The collector shall also grant an opportunity of personal hearing to the petitioner who shall submit a certified copy of the order of acquittal of the order passed by the criminal court in his favor.
Item 24.
Item 24, my lord, I am appearing in the opposite panel 5, my lord. The petitioner filed a rejoinder affidavit. Some disputed documents are there. So short time may be given, my lord.
2017 মସିହା ম্যাটার মিস্টার শতপথী কোন
Short date, any Friday, lord said.
ফ্রাইডে আরো উইক
Next week, lord said.
as requested by Sri Satpathy Learner Counsel to the opposite party, list this matter on 27th August.
Item 25.
Yes,
My lord, the time allowed. Kindly read them.
17, sir. 2017, 3 matters are there. You are appearing for the petitioner.
Petitioner.
I am for the enforcement.
The 2017 matter get ready. As requested by Learner Counsel to the petitioner, list this matter on 2nd September. Parties are requested to come ready for final disposal, for hearing on final disposal.
Item 26.
Item 26 seeking for passover.
Pass over.
Item 27.
I beg on behalf of Mr. Achyutananda Patnaik, this item may kindly be passed.
Pass over.
Okay.
Item 27. Item 27 is not your matter probably. Not your matter. This is a weekly daily. Yes.
Take it. 27. That's it. Brief fact of the case is that 27.
You said that the legal clarification allows for OPT verification.
That is what I have got.
The word clarification. Order dated 5/8/2024, be corrected as qualification. Last time you had said that the initial clarification allows person with OPT qualification to apply under facility category 4. And you are supposed to produce a copy of the clarification.
Clarification. That clarification says, my case is, let's see, since I was a BD, they say, since you have not city passed, your engagement shall not be given effect to. I passed OT81. I filled the form. I selected in the category of trained category. Thereafter, they put me under untrained category. They did not give me appointment. I filed a writ petition before this honorable court. Writ petition was dismissed. Thereafter, I filed a writ appeal. Writ appeal, this honorable court division bench protect me by directing them to keep a post open. Keep a post. They dismissed, rejected, saying that since you have suppressed two things. One thing is you are a BD candidate. You did not say so. And since BD candidate cannot be appointed in the city category, OT81 category. And third thing, you are a hearing impact, that you did not disclose that fact. Let's say in their counter, let me go to the brief. 5 minutes only, lordships.
Impugn order. That's what I am taking, my lord. Impugn order, they filed in their counter. Since they did not supply me, I filed this writ petition since my representative. They filed in the counter, that is page 20, starting from page 21 of their annexure C4. My lord, got it? May I read so that it will be. Last paragraph. That is what they cannot get an appointment. Vice versa. BD cannot apply in category 1.
Category 1 cannot apply for BD category. Category 2 cannot apply for the same.
That is the reason. Then they counter also, they say you have suppressed some material facts. That Lordship, kindly come to my document, revised document, what was asked by my lord. Applicability, 2008. May I read, Lordship? Slowly I am reading. As for resolution dated so Bhubaneswar dated 4/6/2012 of the Government of Odisha Department of School and Mass Education, corrigendum so and so, dated, this is important, without by 2018. This is 18. OTT is applicable to all candidates who possesses requisite academic and training qualification with requisite percentage of marks, and to all candidates pursuing the final year of the teacher training course before the date of publication of advertisement for conducting OTT, who aspire to become teachers for classes 1 to 8 in the school of private aided school and so and so. However, the candidates intending to seek employment as teachers in private unaided schools shall also have the option appearing and central teachers eligibility test conducted by the central government, CBSE, if it so desire. The candidates, after being qualified in OTT, can also apply for further improvement. This is what. Now, this is eligibility. Category 1, city category. Lordship, category A, got it? This is city category. Important aspect, my case, last. Second, or graduation. The impediment, what they say, graduation with at least 50 marks and Bachelor of Education, BEd. Last or on the category A, Lordship, got it? Graduation with at least 50 marks and Bachelor of, that is BEd, on the condition that who has acquired the qualification education from any NCET recognized institution shall be considered appointed as a teacher in class 1 to 4. Provided the person so appointed as a teacher shall mandatorily undergo 6-month bridge course. This is what cover, Lordship. And B category also, they reversing same thing. They have given effect to, and while adding this 2018, they did not restrict anything. 2012, corrigendum was revised on the footing that BED shall be included for the, category 1. If they qualified for that, only they will go for training for 6 months. Except that, nothing else.
Yes. Madam, this is a matter relating to the recruitment year 2014 and 15 matter. And what now it has been presented before Lordship, that is a guideline of 2018, and what is 8 is to guideline of 2019. And
the clarification issued by the
yes, ma'am.
Government.
Yes. Then 8 2013 matter, that is unnecessary A/4 series in pen or 8/9 of my counter. There we have categorized to 2 categories matter.
These rules.
Yes. Guidelines matter.
Guidelines, they do not have any.
They have retrospective application if they say it is effective from this date. Here, that's why on the initial stage I said, Lordship, as per resolution dated so and so and Bhubaneswar dated 22/10/2018.
So what is the law? Where there is no date mentioned, what is the date of?
Effect shall be given retrospectively.
As per the
Law
general
says,
it is prospective.
if my statute, my law line wants to argue statute says, Lordship, every statute is prospective one. It's presumed to be prospective one. If it is given no details, then it shall be treated retrospective one for the because statute is created for the benefit of the employees. And now, Lordship, in the writ appeal, chance was given to me. It is not immediately I have come to before my Lord that 2018 order is to be given effect to. Now, Lordship, kindly see writ appeal order. Writ appeal order at my page. This has to be read with this, Lordship. This has to be read, the statute has to be read with page 29. The rider given by my Lord, page 31, the operative person, Lordship. Lordship, kindly come page 31. On this footing I am claiming, since they did not rejected my claim, as prayed for by Law and Council of Appellate, list this matter, say 16. In case all the posts of Shikshaka have not been below, one post shall be kept vacant till the next date of the listing. Thereafter, disposal. Disposal, Lordships, page 34. Argument were advanced by Mr. Chandrakana, Law and Council for the appellant. He made a request that the appellant may be permitted to withdraw this appeal with the liberty to approach the appropriate authority for redressal of given. Prayer is allowed, Lordships. Now, my Lord has prayer giving me liberty to file representation. Therefore, there is no impediment that since Lordship, then my honored friend, Lordship. Lordship.
So it means the entire period was followed. That does not mean your case will be considered on the law existing on the date you are considered.
Lordship, what is the rejection? Kindly see the rejection to their kindly see their counter itself. Kindly see their counter. What they have developed, Lordship. What my learned friend basing upon page 3, para 7, they are saying it is humbly submitted that the engagement of Shikshaka is against me, they have written. Is a policy decision of the government of Odisha. My Lord got it, page 3, para 7 of the counter. It is humbly submitted that the engagement of Shikha Sahayaka is a policy decision of the Government of Education in school and mass education department. So opposite part 3 to publish fresh notification for such engagement. Moreover, the engagement process for the year 2014-15 has already been completed as a series of recruitment has already been over in subsequent. This year, the 20,000 number of junior teacher has been notified and the recruitment is under process. Now, what is the abhorrent lordship that lordship's division bench order was to keep a post vacant lordship, subsequent to which honorable division bench gave me leave. Now lordship, they say you have suppressed, they say in para 11, they say you suppress. Kindly see my application lordship, page 9.
What they have said, beyond the impure order, this court will not look into. Whatever is available in the impure order, the ground taken by them to reject your application, that is the only thing that the court should accept. That is number one. Number two, I think it would be better if you don't stay under the illusion that the one post was kept vacant. It was kept vacant for some time. When your writ application was submitted on, the interim order goes. Interim order keeping the directing the people keep put vacant. It automatically goes. It must just be
No, doctrine of merger will apply. That is lordship, I am bowed down that. That is the law. Thing is, when an opportunity is given to me to approach before the, therefore my cause of action from that liberty continues till it's a rejection. Therefore, that's why I am before my lord.
As a consideration of your representations of
That's why I am before my lord.
that authority has considered and passed an order. That order we have to test.
Yes.
Now we will come to again the page 21 of the counter.
And before
Lordship
before
only.
into the counter, my lord, my submission as I have made in my counter. I think, my lord, this decision of the project coordinator after the to comply the order of the honorable court in the writ appeal, my lord. That is what we have given in annexure C by 4. That is not a part of the writ petition. And
Exactly what I am trying to tell you.
That my
You have to challenge this.
lordship, my case is
and this case has been filed in the year 2014, 23, and this
my case is specific abhorrent is here in this writ petition. Since they did not comply the order passed by this honorable court, they did not dispose of my representation, but still they kept it pending. Therefore, I filed this writ petition. Thereafter, they now with this counter, they say, my specific paragraph, counter, they say we have already rejected.
That such an order has been passed.
Plus.
This it has been brought to your notice. You challenge it. File a petition for amendment challenging this.
Let's.
Please file a petition amending your application with a prayer to quash this order. Then you will test it.
Let's.
They are appealing this time on merit.
Yes.
They are then open that petition which will welcome.
of 2013, my
No, that also has been challenged. Otherwise,
yes, on the basis of which, my lord, the selection during the year 2014-15 was actually there.
Supposed to know to advise you, but still the annexion, which is at page 8 of the.
My lord, A by 4 series, my lord.
A by 4 series.
Yes, ma'am.
A by 4 series, and this order C
C by 4.
Both you have to challenge.
Let's I'll do within
We like come to the commissioner, request for an agreement, as he wants to file a petition for amendment. This matter in September.
let's see in this month by 29.
Second September. Petition for amendment is a final meeting. I will see the High Court. We are challenged. Then we will not be.
What comes to my mind of my lord, consequential order has to go. If first order goes, consequential has to.
Item 28.
We give any.
Item 28.
I am for this sub item.
My lord, I am filing petition number 35782 of 2023. I am the petitioner Srimati Savita Barik. I am also filed an intervention petition, the subsequent rate petitions. But
Copy of the intervention not been solved to me.
But the matter is very limited to that extent, my lord. My prayer before this honorable court that the petitioner is that the opposite, that is the other petitioner in the subsequent case, my lord. He, in spite of this honorable court's order and the subsequently she has been disengaged by the sub-collector because due to the wrong procedures made by the authorities. And he has been disengaged on 12/5/2023, madam. Sir, my case is that in the year 2011 there was an advertisement and 4 candidates applying for the same. I am one of the candidates. Out of the 4 candidates, 1 candidate did not participate. So that is Hon'Ble Barik, he has not participated, only 3 left. Another thing is that there is a complaint that the Sunyalata Mahapatra is not belongs to the residence of the proposed center, because she is another, except me, other 2 applicants, one is mother, another is the daughter. So there is a complaint before the authority. She is not belongs to our center area, therefore her case is not considered. However, ultimately the mother Sitamani Mahapatra is selected as because she is widow, and thereafter made application before the authority that the certificate issued by submitted by the Sitamani Mahapatra is forged. The villagers and the present applicant come to the honorable. After this, she has been disengaged. Thereafter, for the face out of the 2 remaining candidates should be done. But they could not select, and subsequently 2-3 times they are calling for the Mahila Sabha, and subsequently without following this, without defer on the different pleas, and subsequently they have given the appointment to the Sunyalata Mahapatra, who is the petitioner in the writ. So the present petitioner complained before the sub-collector. These are the situation. 2 times Mahila Sabha convened but not selected, and subsequently they have given appointment. So on the basis of our application, sub-collector has disengaged Sunyalata Mahapatra on, my lord, 22/2023, and subsequently CDPO has disengaged mine. Then, my lord, being agreed by this, the petitioner Sunyalata Mahapatra has challenged WPC number 13303 of 2022. And in this case, in that case, my lord, it is clear that Honorable Court on 27/5/2022 given an order as an interim status quo as on date with regard to continuance of the petitioner shall be maintained till the next date. But as for my lord, there is clear evidence. My lord, this is the letter that is on 15/7/2022, which clearly show that the petitioner in another writ petition is dismissed on 2022. Order is passed on 27/5/2022. So he is no more in service, but the authority has allowed and continue the present petitioners. My grievance is that, my lord, as a present petition, my grievance is, I am the only eligible candidate. I should be appointed. My lord.
What I find from the order of the subject,
Yes, my lord.
the mandatory requirements for the population that is holding etc. were not found. So the only thing that this court can direct is to conduct the selection process afresh, taking the two candidates.
Yes, my lord. I have no objection. I have no objection.
My lord.
Yes,
I have no objection. आगे प्रेस दी जन को भीतर देखिए who is eligible.
Mohila Sabha got to head due to apprehension of law and order situation as stated by CDP.
My lord.
As per government guidelines, Mohila Sabha
Yes,
is a
ma'am.
mandatory requirement. And for further also out of the 3 number of selection committee, the ANM in charge was also absent. So the procedure was not proper. Proper procedure and step.
My lord.
My lord.
My lord, I have no objection.
and my lord, with respect to the status of the present opposite partner number 5, who is the petitioner in the second case, my lord, Sunyalata. I was stand in the counter, my lord, by virtue of the interim order granted by your lordship, and she still continue.
Whoever is committing stands for movement.
My lord, that is I am showing.
I have recorded something.
Yes.
I
No, my lord only recorded.
The state council is saying that
No.
order has been passed and accordingly she is continuing.
That is a specific affirmation in the counter, that is what I meant.
My lord only recorded that. My lord, he has come to the court and got an order.
I will, get the order. If
Yes.
there is any mistake, please point it out.
Obliged.
Please point it
Obliged.
out. Would be read application. Involved. In the same issue. And where the heard together and are being disposed of by the government. The only reputations were applicants for Hon'Ble worker of Bonasa, Hon'Ble center. In the respect of arbitration. The petitioner in the PQC number 9.782 from the right claims to have been selected.
My lord.
Claims to have been selected. But it was not favored with the order of order engaged. The petitioner so, where is the order? Where is the selection? You just refer to, you are talking about it.
My lord, I am Sobita Bari. The entire record shows that out of 4 candidates, one is disengaged due to the only 2 candidates is remaining Sunyalata.
Election letter, my lord, page 12, my lord, of my read bits.
The petitioner is the petitioner of 133 for engagement. By order of the individual was there.
My lord. Well,
Challenge the election of by committee a representation before the sub-collector.
11.
By order dated 26/4/2020, sub-collector found that proper procedures had not been followed for selection of directed for dissatisfaction or dissatisfaction. That order has been challenged by Sashikanta Mishra in the petition number 12203 of 2002, wherein by order dated 27/5/2022, the coordinate bench of this court
directed as an interim. That status quo as on date, as on that date. With regard to continuance of the case, very similar shall be maintained till next year. Then at state council, the comments on instructions that pursuant to interim order, has been continuing as an ever.
Yes.
This is seriously object of course by the most of object. Then council for submit the right. By submitting that, has already been disengaged from this kind of the order of this.
Well, on 12/5 to.
This further submitted that she having been originally recommended and she having been originally selected ought to have been engaged as an order. The reason of the order person is subject on 26.2022 reveals that mandatorily required to be held to be convened for the purpose of election was not. Further, one of the members of the selection committee being ANN prepared health worker female in charge of the Annual Center was also absent. And on what is your way to such being the factual aspects, such being the factual solution, it is evident that the selection, it is evident that the selection of Sundarata Mahapatra was not properly done, was not done as per by following the proper procedure. Since there are only two candidates, BYING lying for the post, without keeping the writ applications pending any further, please go. In this time, let's go in the time of Mr. Law, saying with direction to the sub-collector direction, pass necessary orders for selection of Hon'Ble worker of Ponsa Center, Nobody Center, afresh according to law. By following the due procedure required in the guidelines. The selection process as above should be concluded within a period of
2 months.
2 months.
2 months. From today.
May I-
Till that date, the petitioner.
may I for-
What is it?
Sunyalata Mahapatra.
How to be working, shall be allowed to continue. The conclusion of this election.
Well, Lord, one thing I want to draw the attention, if it will be reflected, it will help to the authorities. I have annexed one, annexure 8 in my writ petition page 39, my lord. I want to draw the kind attention. It shows that on 6/7/2022, the petitioner is joined in the job. Well, Lord, thereafter, I want to show that your lordship may kindly glance to the page 41. 41, under the act, we got that post of vacant ରହିଛି dispute ପାଇଁ ରହିଛି ପଣସା ପାଇଁ ଲେଖା ହେଇଛି. Page 41 re and page 42. On dated 9/7/2022, there is disputed and vacancy.
This court to the appointment letter. Dated 6/7/2020. Issued in respect of issued in favor of similar amount. The further draw the attention of this court to the information regarding vacancy of different anomaly centers. Given by the CDQ of Orissa on 9/7/2020. Wherein Orissa anomaly center has been mentioned. According to say Bhakti therefore, Vinodata Mathur was never removed.
Right.
As on 9/7/2022. Orissa anomaly center
No, sir, 2020.
was after the was shown as the records.
My lord, with due apology, one thing, the authorities are what are going on, we are also aware to that extent. Observation, my lord, on 12/5/2022 at Annexure 4, filed by my learned friend in his writ petition shows that एतद्वारा आपन को जणे बालेश्वर पत्र संख्या 26/4/2022 जे आपन को 12/5/2022 तारिख अपराह्न शो कार्य अंतर करा गला एटा छुटाला आ माय लॉर्ड ऑर्डर ता हो 27/5/2022 रे दिस ऑनरेबल कोर्ट इज डायरेक्टेड एज एन इंटरिम मेजर स्टेटस को एज ऑन डेट विथ रिगार्ड टू कंटिन्यूएंस ऑफ द पिटिशनर शैल बी मेंटेन्ड सो माय हम्बल दैट जे ऑर्डर हला
By the time of passing out. Interim order by this court. Vinodata Mathur had already been disengaged on 12/5/2022.
my lord.
Item 29. In item
Urgent set.
in item number 29, my lord. On the last occasion also, my lord, on 22/7/2022-24. I had submitted, my lord. I have already received a Paravage comment in this case. And I have contacted them, my lord. Paravage comment, my lord. Because there is an interim order, my lord, may I pray, my lord, this matter will be taken up next week or 1 week after, my lord. By that time, my lord, before that, my lord, I will file the counter. In September. Before that, my lord.
The request sometime.
Yes.
This is not on second December. After is there any value in time? Interim order.
Item number 30.
Similar to शकतो.
इथे पाहिजे नाही काउंटर काउंटर टे दे देइछि ई फाइल कर दे नहीं एटा पर अपन कॉपी सर्वे हां अपन कॉपी सर्वे मो एटा गले हार्ड कॉपी टा
Three शकतो काउंटर Three शकतो.
Item 31. Item 31.
31, my lord, I am for the petitioner. Opposite party husband has not yet appeared, my lord.
Right. It's not clear, not conclusive as regards. The constitutional petition is directed to take text of this. It's very beautiful. For which shall be filed by tomorrow. Topic number 18. There is matter on.
2nd September. Upwards. 9th September.
9th September. It's not.
Item 32.
Mr. Nursing, my lord, item 32 not pressed.
Item 30 on behalf of M. Basu, mediation is continuing.
Item 36.
This matter petitioner is the wife seeking for transfer of the civil proceeding from the Judge Family Court Kotak to Judge Family Court Bhubaneswar matter. And the ground is that petitioner is a old ailing parent and depending on the pension of his parents, man.
Notice has not been issued. Call it take notice. 23rd September. No, it has fresh admission that. 23rd September. Have you removed the defects?
Yes, ma'am. Stay, ma'am.
23rd September, stay.
Bhubaneswar.
Item 37.
May I please, Lordship? In this case, mediation is going on. First, maybe
Report of the mediator and district court dispatch number 117. Let us call for that. Judge in charge लिखिले जे माने सर्विस रिटर्न टा already communicate ही जाइची to the High Court. But 27/4/24 सेटा आसी जब office to tag the R10 register dated 27/2024 and district court dispatch number 117 dated 27/7/2024 referred to in the letter dated 8/8/2024 of the judge in charge process establishment Bhubaneswar process establishment section Bhubaneswar and then next tomorrow Friday on 16th है
Interim order.
to continue. Item 39.
May I please? The opposite party is the mother-in-law.
The mediator, the report of the mediator indicates that mediation procedure between the parties has become unsuccessful. Yes.
The opposite party is the mother-in-law. The petitioner is the daughter-in-law.
There are three petitioners.
Yes. Petitioner number 1, the daughter-in-law. Petitioner number 2, mother of the petitioner number 1, Samudhi. Opposite party, the Samudhi.
And who is petitioner number 3?
3 is the maternal uncle. Opposite party filed a DV case before the JMFC Bhubaneswar. I want transfer of the same to the Raulkela SD. Why? All are residing there and another DV case is pending before institution of present DV case. And where the opposite party has already appeared and filed the so-called.
Yes.
Yes, my lord, both are working lady and opposite party is the mother-in-law and cause of action at Bhubaneswar, my lord, and residing at Bhubaneswar, and he is at the age of 57 or 58. So my lord, jaha karibe.
Lady ଅଛି ତାଙ୍କ ବୟସ ବି 60. Allow କରିବ allow କରିବ on the ground set allow.
Then my lord, permit for this.
ଅଛି virtual mode କରିବ virtual mode or not not necessary absolutely necessary.
Okay.
Item 40.
Maybe permitted. Oh, virtually,
Virtually ତାଙ୍କୁ allow. ତାଙ୍କୁ allow ନାହିଁ. She will submit an application.
Yes.
That will be considered by the court.
She is also the divisions in the Raulkela. Both mother-in-law.
I have allowed it. Transfer টা allow কলি.
Item 40.
Pray for VC, my lord, allowed for VC.
ସେଥିରେ virtual mode ପାଇଁ ଆପଣ ମାନେ you have to file an application before the concerned court. Depending on the availability of virtual slot, he will grant you.
Mediation report is there. Clerk C.
Clerk C.
report of the Secretary DLS Subarnapur indicates that the mediation proceeding between the parties has failed. The transfer application is therefore taken up for hearing. Yes. From go to Bargod to Subarnapur. Yes, what do you say?
She has appeared before the Judge Family Court Borgad and filed section 9 petition and appeared there. Now she seeks for transfer.
This is a section 9 application.
No, I filed 13 application. On that application, she filed section 9 application. Appear there. Now seeking for
Yes.
transfer.
Why?
Your worship,
So Badele mediation center.
that is.
There is a report.
No, there is no
Assaulted.
such.
Who is?
No such.
ଶାଶୁ ଆଉ ସେ ମୁଁ ଶୁଣିଛି ଯାହା ସେ ମିଡିଏସନ ସେଣ୍ଟର ବାଡିଆ ପିଟା ସୋନପୁରରେ ଲେଖିଛନ୍ତି କି ନାହିଁ ମୁଁ ଜାଣିନି
No, something କିଛି incident ହେଇନି as per my knowledge.
Dekhi
and petitioner lady my lord having a child.
But you yourself filed a section 9 application.
Yes, sir.
That information is not with
Yes, sir. That is.
You take instruction.
my lord.
That is there.
Counsel for the opposite party submits that the present petitioner has filed an application under section 9, okay, 9 of the Hindu Marriage Act before the Judge Family Court. So, the Pondal and counsel for the petitioner wants to take instructions in this regard from his client. Let this matter. 27th August.
Interim orders.
Interim order to continue. Stay.
Item 41.
Petition is the seeking a direction to transfer the MAT case number 18 of 24 filed under 9 of Hindu restitution conjugal right marriage.
Now, let us see what happened to the notice.
Opposite party has
Somebody has appealed.
yes.
Is not there. Pali ki rakhiya. Sri Paul, learned counsel for the petitioner, is present. Sri Paul and Dr. Paul. The Paul, learned counsel for the petitioner, is present. None appears for the opposite party. Let's this matter tomorrow. If it doesn't appear, we'll dispose of it.
Item 42.
The transfer application has been filed to transfer the MAT case from the learning civil judge senior division come family judge Banke to Bhubaneswar. I'm for the petitioner, wife my lord.
Somebody has appeared for the opposite party.
Yes, last date.
Tomorrow. Last date में क्या appear करो?
Last date appear करथिले.
Learned counsel for the petitioner is present. None appears for the opposite party. Let's this matter tomorrow.
Item 43.
Well, in this case, the notice was issued to the informant.
It has been served.
Notice has been served.
27/7 on the last
This
occasion.
is a SCST matter.
My lord.
SCST.
Learned State Council submits that notice on the
Last
government.
occasion, it has been reflected in the order.
Learned counsel for the appellate is present. None appears for the opposite parties. The informant, on whom notice has already been served. The appeal is therefore taken up for hearing. Yes.
My lord. The petition is in 12/2021. Initially, the case registered for commission offence under section 307 and other offences, subsequently turned to 302, my lord.
You have the case diary?
Case diary is there. Your Lordship, I want to show you last order, Your Lordship rejected. In CRLA 533 of 22. Order dated 24/11/22.
Dying declared.
Yes, by going through the same, Your Lordship has rejected. And he has been implicated by the deceased, my lord. And now in the meantime, 3 to 4 witness has been examined.
Bring the copies
So-
of the depositions.
My lord.
That in the rejection order, it has also been showed that PW 1 and 2.
Dying declaration alone may not be.
My lord, dying declaration of the injured statement was recorded. But he is not dead. He is not dead.
Mother and son. Mother has survived and son has
Son of the
succumbed
dying
to-
declaration nahi.
Son or nine?
No.
No,
Only mother.
sir, na?
No, son or nahi. Only mother.
Son.
Chanchala Behera, page 64.
Dying declaration लिखा ही छी.
And that is the Chanchala Behera.
Chanchala Behera, injured.
She is not dead.
She is not dead.
The 161 hala.
But Lordship, see the rejection order.
I've seen it.
In the
I've seen it.
meantime, two witnesses has been examined.
In the meantime, you obtain the declarations.
Mala.
So for the appellant shall obtain, shall produce the copies of the examined in the ongoing trial. In the meantime, yes. Place this matter on 2nd September. So 44.
Item 44.
Time is granted till December 2024 for disposal of the case. Yes.
Item 45.
Right.
Modification? What
Yes, sir.
modification?
Lordship, allow the application in respect of 1, 2, and 4. Condition number 9, 1, my lord.
9-1, yes.
Yes, sir. They shall appear personally before the
Make it once in a week. We'll make it once in a week.
once in a month. They're laborer. Till today they are appearing. What I can say, each day they will appear in the trial, my lord. Your lordship indicate that.
Every alternate Sunday. Considering the submissions, they prepare for
15 days.
every alternate 15 days. Considering the submissions, the prayer for modification is allowed. Condition number I of paragraph 9 is hereby modified to the extent that only to the extent that shall appear personally before the Beguniapada police station on every alternate Sunday, and such fact shall be certified by the IIC to the concerned court once in every fortnight. That's all. All other conditions shall remain intact.
Obliged.
Item 46.
Item 46 prep for 1 week after.
1 week after is prepared for.
Item 47.
Maybe yes. Your lordship, on road, apply lordship. Your lordship 498, 306 and 304 lordship. It is and he is in custody lordship 3 years and 3 months lordship. Lordship only not inclined that it is a born injury lordship. Admittedly, at the time of occurrence, nobody was present. Neighbor says that Gobard Bhangi ki bito pasiki dekhilo, dead body was lying. In the meantime, lordship, some of the witness has been out of 30 chassis witness lordship, 6 witness has been examined lordship. Out of 6 lordship, 4 witness is a neighbor lordship. All are stated that lordship at the time it's not family members are not there. It is not having an auto driver. He went to the driving to the station. The witness after the smoke was coming from the house, they entered into the house, broken the door, and they have to also rescue the deceased. At time lordship deceased was
Mumtaz Ara.
again. In the also 3 months again jail rahichi. दया करून जाएगी 3 वर्ष 306 lordship 306 498 302 not there lordship as it pertains. Each date appear for lordship trial?
No.
Any torment concern lordship? नॉर्मल इंटरव्यू ले मिलो किछि जमा
अप्लाई करो
वो देई जाए आइए देई छोड़े आइए देई लordship आइए lordship
466 of 2024. Therefore, interim bail has been made on the ground that the father of the petitioner is suffering from several diseases for which he is being treated at SCB Medical College and Hospital at Cuttack. His doctor has advised him for higher treatment. It is submitted that the petitioner is the only earning member of the family, and there is also no other person to arrange for higher treatment of his father. Current State Council, the prayer for bail, oppose the contentions by submitting that. No, but clearly submits that considering the grounds cited, the court may pass appropriate order. Having regard to the submissions as above and the ground on which the prayer for interim bail has been made, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 2 months. On such terms, please the main bail application for hearing. 21st October. 21st October.
Thank you. God bless.
Item 48.
Here this petitioner is in custody since 22/8/2022, my lord, on remand. On the basis of the co-accused confession, my lord, he was arraigned as an accused in this case, my lord. And the prosecution case is, my lord, 3 persons outside. And the police got information that they are carrying ganja, my lord. And ganja posta was seized and that counts to 640 kg. But the petitioner was not present at the spot, my lord. And the rejection order, your lordship,
Earlier rejected by Justice Satpathy and also me.
your lordship says, once your lordship says.
You were arrested at the spot.
Not spot, my lord. Your lordship may kindly see the rejection order.
But anyway, I have passed an order on merit. While IA will consider.
What is the urgent sum of
Is this matter on 27th August, as learned counsel for the petitioner wants to file an IA.
Obliged.
Item 49.
May it please your lordship, my lord. While the co-accused persons similarly situated have been released with this honorable court, my lord, the basis of implication there is that statement of co-accused. Here also similar footing, my lord, the FIR was lodged that unknown person fired at the five my lord friends who are got Bansadhara bridge. There unknown person came. This petitioner, my lord, the statement of Y. Venkat Rao, lordship may can say Dasari Venkat Rao.
Does he stand on the same footing?
My lord, the co-accused person, they have been released on bail, they are on 120B. But against them, against this present petitioner, 34 is there. Against the main accused who was fired, my lord, that B. Rajesh alias Raja, is a Supari killer. He has taken Supari and those persons who have granted bail, they have supplied a gun. And this B. Rajesh Raja, he has fired, but he was along with accompanying the main accused.
So how do you stand on the same footing, Mr.
Not
Ras?
on
My lord, this same
Those who have
statement,
released,
co-accused
they are
statement,
120p.
my lord, this, your lordship may kindly see. ଏହା ପରେ ମୋର ସାନ ଭଣଜା ରେଜିଷ୍ଟ୍ରେସନ ଗୋବିନ୍ଦା ଗୁଡାରେ ରହୁଥିଲା ସେଇ ସୁପାର କିଲୋ ଭି ରାଜା ସହ ଯୋଗାଯୋଗ କଲେ 30 ଏଇଟା ମୁଁ ଏଥିରେ ନାହିଁ ବଂଶୀଧରା ବ୍ରେଜ ଉପରେ କଥାବାର୍ତ୍ତା କଲା ପରେ ଏଇଟା କୋଟି ଦାସ ଭେଙ୍କଟରାଉର बीच राजा और तार सांग मुना लिमा कान्हा प्रधान सहित मिसे मोटरसाइकेल सेटा पहुंचला एतिकी तापर मु चली आसली मतलब मैं काइंडली से आई हैव गॉट द ऑर्डर लॉर्ड्स में काइंडली फॉर ए मोमेंट
Which order? Which order?
the मतलब रिलीज ऑफ 3
I have the order.
yes my lord obliged my lord. So my lord the same footing my lord apart from the co-accused no implication खाली मोटरसाइकेल रे जाइतली और राजा कला जो यो लॉर्डशिप राइटली नॉट रेफर आउ राजा जाई के आउ गोटे जगह रे विषय पड़ने ताकू के मारी देले सेथरे नाही सेउडा भी एथे नाही आई एम ओनली 3 persons have been released on bail man your lordship may can see my name is Muna Lima आउ गोटे मुना बेडिका अछि my name is Muna Lima मु केवल मोटरसाइकेल जाइथली से ब्रिज जाए other similarly situated person those who have been released on bail मतलब they are also same footing this is the position my lord I am knocking no role
This present petitioner on a motorcycle, but he was there. And
yes,
B. Rajesh, he has fired, my lord. B. Rajesh alias Raja. But he was present at the spot along with B. Rajesh.
भिरियस तो दूर मागिले मारले ये हमें तो मोटरसाइकिल छाड़ी पड़े
Bridge.
You give the statement.
This is not the only that disclosure statement of Rajiti Krishna.
The petitioner is in custody since
12/7/23
Who is the main conspirator?
13
Please
मास
disclose
है
the statement, my lord.
Okay.
Yeah. At
12/7/23 13 मास है
12/7/2023
12/7
in connection with such and such case. It is submitted that the petitioner stands on the same footing as the co-accused persons, namely Dasari Venkat Rao, Ravi Jagannatham, and Akash Kumar Bodapu, who have been released on bail as per order passed by this court in bail appeal numbers 1. In the bail application number 6. It is further submitted that, except for the statement of the co-accused that the petitioner was present with the spot, having gone there on a motorcycle, there is no other acceptable evidence to show his complicity in the alleged occurrence. Learned State Counsel has opposed the prayer for bail by submitting that the other co-accused persons were allegedly conspirators, whereas the present petitioner has been implicated with the aid of section 34 of CRPC. After going through the submissions and on perusal of the materials available in the case diary, this court finds that the sole basis of implication of the petitioner is the so-called disclosure statement of
Rajiti Krishna.
of co-accused Rajiti Krishna. No other acceptable evidence against him. Under such circumstances, I am inclined to take a lenient view. Let the petitioner be released. One करो each day appearance कर देवे तापरे he shall not leave the territorial jurisdiction of the court without obtaining leave. Tape shall not threaten the witness. Yes.
obliged.
Item 50.
Yes, of 302 and 307. And my lord, so far the involvement is concerned, my lord, that there is lack of my lord premeditation, and this is a case of sudden provocation, dispute due to my lord digging up the bore well in a place. Two is narrated in the affair. In the morning hour.
What is your name?
So far, my name is concerned, my lord. My name is Anua alias Santosh Dev. And allegation of assault attributed to Tolia Devri, Kalia, Pintua, Bhisma, Ananta, alias Abhi. Your lordship dealt the matter, so far the co-accused person is concerned, and was inclined to release them on bail.
I rejected the bail application of Kuramani, Koilas and Dhruvam.
Yes.
This petitioner is my lord. Panwale.
I am inclined to other person respect to public. No, how kahara reject hichi?
Reject hichi.
Ananta Devri.
My lord. Because there is rival allegation of assault by the Ananta Devri to be deceased.
What is his role? Yes.
The case diary is not available.
Let the case diary come.
Yes, madam. But in the
Case
next
diary be
item,
obtained.
similar, another accused are there, they have the. allegation of-
Case diary be obtained.
18 January.
List this matter on 27th. On 2nd September. Other matter? Same.
Item 52.
Yes.
May it please, sir.
Item 52, it's a RSA of 2022. Here,
Approval number 52 is not yours. This is of the another list. Yes.
यदि कोर्ट नेम टा खाली चेंज हो
Either भूलेजी order है.
नहीं ମୁଁ ଭୁଲ ଲେଖିଥିଲି ଭୁଲ ହେଇଛି
Learned counsel for the petitioner is permitted to correct the cost title କରିଦେଲା ହବ.
କୋର୍ଟ ଟା ପୁରା ଆପଣ ଡାଇରେକ୍ଟ କରିଦେଇଛନ୍ତି ନା କୋର୍ଟ ଏଇ କୋର୍ଟ
ନାଇଁ ଆପଣ କୋଉଠି ଭୁଲଟା କୋଉଠି କରିଛନ୍ତି? cost title କରିଛନ୍ତି ନା ଭିତରେ କରିଛନ୍ତି?
Post title to ଅଛି.
Achha, so is permitted to correct the name of the court occurring in the participated bail application in the office. Certified copy nahi chindi. The certified copy be submitted for correct. Oh,
ନାହିଁ.
nahi na.
ନେଇଛି ଯେ ଜେରକ୍ସ ଟା ଅଛି ସେ ନେଇଯାଇଛନ୍ତି ସାର୍.
କଣ କରାଯିବ ତାହେଲେ? Certified copy ଟା ଦବାକୁ ପଡିବ correction କରିବା ପାଇଁ. Whereupon the order dated 17/5/2024 be corrected appropriately.
ମୁଁ post title ଟା correction କରିଦେଲେ.
Yes, be corrected appropriately.
And date and
2 weeks further time is allowed to the petitions. Yes.
ମୁଁ ଏଇଠି କରିଦେବି.
ଏଠି ପରା 24 ହେଇପାରିବନି ସେଇଟା problem.
ଆଜ୍ଞା.
2024 ଟା ଅଫିସରେ କରିବେ ଏଠି ହେଇପାରିବନି because we don't have a physical file here. That is the problem.
ଅର୍ଜେଣ୍ଟ ସାର୍ଟିଫାଇଡ୍ କରିବି. ମୁଁ ଆଜି ଯାଇ କରିଦେବି.
All right, urgent copy.
ଆଜ୍ଞା.
ପାସପୋର୍ଟ ଦେଖିದೆ ଏରି ଗୁଟ ବାଜିଲାଣି ପାସପୋର୍ଟ କେତେଟା ଅଛି ହଁ ଦେଖିଦିଅ ଗୋଟେ ଦିଟା ଦେଖିଦିଅ ଗୋଟେ ଦିଟା ଦେଖିଦିଅ
Passport item number 4.
The transfer application by the wife. No, but because another 3 applications are pending at Cuttack.
Mr. Mahathi, normally from Bhubaneswar to Cuttack or Cuttack to Bhubaneswar, I am very slow to interfere.
No, fact remains, I am conscious mela. Fact remains, what a private company काम କରୁଛି and even only after 4 days of marriage, this incident has
All right,
occurred.
take notice. Notice, stay.
Aye.
Debut kariye 23rd September. Yes.
Passport item number 14.
Obliged.
Item 14. Yes, Ms. Mahapatra. Ms. Dipali Mahapatra. Nanti disposed of, none appears disposed of. ଆଉ ପାସପୋର୍ଟ କଣ 2009 ଥରେ ପାସପୋର୍ଟ ସରିଲାଣି ସେ ଆସିବିନି ଆଉ ନାଇଁ ନାଇଁ ସରିଲାଣି ତ ଦେଖନ୍ତୁ 2009 ମସିହା ବାଟରେ ଆଇ ନଟ୍ ଗୋ ସେ ତାଙ୍କର ନୁହେଁ ସେ ବୋଧେ ବ୍ରିଫ୍ ଦେଇ ଦେଇଛନ୍ତି ନହେଲେ ସେ ପଳେଇଥାନ୍ତେ ଛାଡିକି ଯାଇଥାନ୍ତେ ହଉ ଆଇଟମ ତାପରେ
Passport item number 15.
15 none appears disposed of.
Passport item number 26.
2009 ମୁଁ dispose of କରିଦଉଛି
ଫାଇଲ ତ ନାହିଁ.
ଆଉ with liberty ସେଇଥିପାଇଁ ମୁଁ କହିଲି ତ ଆଉ ନହେଲେ ଆପଣ ଛାଡିଥାନ୍ତେ
ଆମେ କହୁଛୁ ଅନ୍ୟମନସ୍କ
ସମସ୍ତେ ଆପଣଙ୍କ ପାଇଁ କହୁଛନ୍ତି କିନ୍ତୁ ମୁଁ ଗୋଟିଏ ଏକୁଟିଆ ଲୋକ ମୁଁ ଛିଡା ହେଇଛି ମନା କରୁଛି ନାହିଁ
ନାଇଁ rightly said.
ମୁଁ କେବେ କୋର୍ଟ ଇଜ ନେଭର ରଙ୍ଗ So dispose of with that order granting liberty to. Yes, item 26.
May I please, ma'am? The petitioner has the order under annexure 8, my lord. The fact of the case is like this, my
Annexure
lord.
8.
My lord. Annexure 8 is
You are challenging the Anganwadi appeal.
my lord.
Final disposal ଏଇଖିଣା କରିବା final disposal କରିବା ଇ ତରତର ହେଇ କରିକି ଲାଭ କଣ ଗୋଟେ ହେଇଗଲାଣି
Launch for.
ସରିଯାଇ ପାରିବ
ହଁ ସରିଯିବ
ଆଉ ଗୋଟେ ଦିନ
ସେ କାଉଣ୍ଟର ଦେଇ ଦେଇଛନ୍ତି ସରିଯିବ
We are relying upon a guideline, my lord. Sir, next week, man. Sometime.
ହଉ let's just matter next week.
ସେ ଯୋଉ ଦିନ ହଉ ସରିଯିବ ବାଡେଇ ପିଟି ହଉ
Passport item number 33.
33 none appears disposed of. Repeated course ଦି ଆଗୁତରେ ଯୋଉ ଅର୍ଡରଟା କରାଯାଏ ଦେଖିଦେବେ ସରିଲା
Passport item number 34.
dispose of ସରିଲା
Other list, we both are present.
it will be taken up after recess.
ସେବେଟା କିଛି ନାହିଁ ଖାଲି ହିୟରିଂ ପାଇଁ ରହିବ
କୋଉଟା
ଆମେ ସବୁ appear କରିଯାଇଛୁ
item 7
ସେକେଣ୍ଡ ହଁ
ହିୟରିଂ ରହିବ କଣ ଆଜି ତ ହିୟରିଂ କରିବ
ଅଛି ହିୟରିଂ ପାଇଁ ଆଉ ଦିନ
LCR ଆସିଛି
LCR ଆଜି ସବୁ
LCR ଆସିଛି ଆଉ
ହେଇପାରିବ
କାହିଁକି ହେଇପାରିବନି ଯୋଉ purpose ରେ ଥାଉ ଦେଖ ପଡିବ
I am not ready.
ସେଇଟା କହୁନାହାନ୍ତି ଆପଣ
ଆଜ୍ଞା ମୁଁ ତ କହୁଛି ଆଗରୁ ଆଉ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ କରିଦେବ
ମାନେ let it be called up and fix a date.
I will not
You ask your associate anybody to be present, I'll fix a date. When do you want to tell me? Who was your matter?
96.
96?
No, 2000.
2007, na?
2007.
Okay, okay, the old matter. So we'll take it up and I'll fix a date. Ask somebody to be there.
ଗୋଟେ item number 1 ଯୋଉଟା ଅଛି ଆଜି ବି hearing ପାଇଁ ଅଛି the my lords have already fixed the specific point of law. Maybe taken up tomorrow or
No, aji je no, aji pass over kar dele. It will be in the list, the weekly list. No, ask somebody to make a pass over.
Pass over for the day.
Pass over for the day.
yeah.
To hear the matter, and the other party took time twice, man. So they are early morning, they said that next week it will be fixed on 20th or 21st. This will be finished on that day. No further adjournment they will be taking.
Yes, what do you say? Item 47 as paid for this matter in the week commencing 20th August. 20th August.
I know it will be taken up on that week, man.
Okay.
That this case may be taken up on that day, my lord. Because
It is made clear that shall be granted.
my lord,
Parties are requested to come ready for final hearing.
20th,
August, say week rest. It will come in the weekly list.
can it not as a part of
It will reach, don't worry.
my lord, on 20, he has given a condition that on 23rd he will be absent. That's why. That's why it must be disposed of by 20.
If not in that week, then the next week it will be
My lord,
disposed of.
I am harassed because I have filed. Because they have sold out the land, my lord.
This has been pending since the last
My lord, my lord, this must be
taken up. Don't worry, it will be taken up. It will be taken up. It's not as if, yes.
Madam.
Weekly list item number 1.
Item number 1 take pass over magutre pare.
Yes, ma'am.
Pass over.
Pass over, ma'am.
All right, pass over for the day. Yes.
Item number 2.
Lordship, may I seek a password for a day?
Wait.
We need some more preparation. We have the judgments, but we need.
I think I had asked you on the last occasion to prepare.
Yes.
You or somebody else, I don't remember.
Well,
Anyway,
you know, my senior was appearing himself.
correct, pass over.
Item number 3.
In item 3, to my learned friend for day after tomorrow if it doesn't inconvenience.
Pass over for the day. Day after tomorrow likh do. Day after tomorrow likh do. Yes. Item 4. Item 4.
This is that matter on the ground of delay. The lower appellate court has simply dismissed the appeal on the ground of
I think Mr. Barik was.
14, section 14 and 5.
Yes.
The interplay between them. I had
Mr.
given a
Yes.
privy council judgment and one Supreme Court.
My lord, here a judgment which was first month of September 2010 is sought to be challenged before the learned district judge after a lapse of 11 years by the defendant. Filing an application for condoning the delay, he has filed an application under section 14, read with section 5 of the Limitation Act. But my first respectful submission would be that section 14 may not be applicable because this was at the instance of the defendant. May I place the provision matter?
Yes.
Section 14.
What is it? Limitation Act. Limitation Act. Apan pado.
Section 14, exclusion of time of proceeding bona fide in the court without jurisdiction. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence, another civil proceeding, whether in a court of first instance or appeal or revision against the defendant shall be the proceeding relates to the same matter in the suit and is prosecuted in good faith in court, which from the defect of the jurisdiction or other cause of the like nature is unable to entertain it.
Then second, in computing the period of limitation of any application, the time during which the applicant has been prosecuting in due diligence another civil proceeding, whether in a court of first instance or appeal or revision against the same party for the same relief, shall be excluded where such proceeding is prosecuted in good faith in a court which from the defect of cause of a like nature is unable to present it. Well, my responsible submission is here it is not the plaintiff who is prosecuting with due diligence. Here the plaintiff's suit was decreed. The defendant now seek to challenge that very judgment. The ground which was taken by the defendant before the learned district judge is that since I was wrongly advised to file a suit, so the exclusion should be given as contemporary section 14. My first submission is this because he was not the plaintiff, he was the defendant, and he doesn't come within the scope and ambit of section 14. It is for if the plaintiff was prosecuting a case before the wrong forum and it is found that
No, I get your point, but
my lord.
but even assuming for a moment that section 14 doesn't apply.
My lord.
The
And
fact
that
that
section 5 will apply.
no,
My
we'll go to that.
Sorry,
We'll go to that. Supposing section 14 doesn't apply,
my lord.
but fact remains that he had preferred another suit.
Yes, yes,
Whether such fact cannot be treated as a sufficient ground
yes.
on facts.
My lord, on facts.
On
Yes.
facts.
Yes.
Let us forget about the law.
Nah.
Limitation question is always a mixed question of fact and law.
It is a fact on law and
So the court, supposing the district judge considers that for this reason, he had not filed this appeal.
yes.
He had filed another suit wrongly advised or whatever to set aside the decree passed in the former suit. It is possible. It is quite possible that it may be also be treated as a sufficient ground.
Yes, but to that effect, my lord, my submission would be what the ground has been taken is because I was wrongly advised. Instead of filing an appeal, he could not have filed an appeal at that time because he was not a party to the proceeding. His father was the defendant and father was alive. So father could have filed an appeal. He could not have. He could have also but seeking leave of the appellate court, saying that I am ultimately going to be prejudiced. So leave may be granted to file an appeal. But he could not do it because his father was alive. So therefore, what he did is he filed this suit as a next friend of the father, alleging that my father was of unsound mind and this decree was obtained by fraud or other thing. And he pursued that. My lord, if I want to challenge the decree on the ground of fraud, I can file a suit. And the competent court is the civil court. So it is not that the matter has been filed in the wrong court. The civil court is competent to adjudicate the matter whether the decree has been obtained by fraud or not. So, taking an exception to that, if I prosecuted in a wrong forum, then certainly he could have said that no, but the civil court was having jurisdiction to entertain it, and civil court had contested, the matter was contested and ultimately dismissed it. And against this order also he has filed an appeal, my lord, which probably it has not been disclosed in the appeal. He has already filed an appeal, and appeal has been admitted by condoning the delay. That appeal has been admitted. So the reason which he took that the decree was obtained by fraud, that can be adjudicated depending before that. Now at the same time he wants to challenge the very earlier judgment between me and his father, and said that delay may be condoned because I was wrongly advised to file the suit. But my responsible submission is, all right, once you say that you are wrongly advised to file the suit, again you are wrongly advised to file an appeal against that. And that appeal has also been admitted. So the reason for which he is pursuing this matter, he can very well agitate before the appeal because appeal is pending there.
All right. Yes. Anything?
And to that effect, my lord, the judgment which has been submitted, referred to in the impugned order itself, that is 2007 Supreme Court, and also the judgment of my lord Justice Deepak Mishra, that is that Calcutta case. My lord, Isa. In the both, one was under section 14, another was under section 55 of the Limitation Act. and the Honorable Supreme Court has called out the reasons under which circumstances Section 14 can be applicable and in which circumstances Section 5 will be applicable. And my lord, I will also cite judgment, the Section 14. So for Section 14, so there is a latest judgment of the Supreme Court also. I have got it. Your lordship can also see to it. There, well, what has happened? There was a decree in favor of the plaintiff. Instead of filing an appeal execution case before the civil court, he filed an execution case before the Tahsildar in the Jammu and Kashmir. There also the Supreme Court said that was beyond time. It was dismissed since it was beyond time, and the Honorable Supreme Court, because he was pursuing the remedy before the wrong court, it has to be excluded. Even to that extent, my lord, this so far law is concerned, there is no dispute about that. But so far the facts and circumstances, the particular case is concerned, my responsible submission would be that it is not a case that he was pursuing his remedy in the wrong forum. And therefore, the guidelines which has been called out in 2007 Supreme Court, that will not be in any help to the appellant here. And so far, Section 5 concern also, the Honorable Court said that whether it is a case of inordinate delay or a short delay, but certainly someone after 11 years cannot say that there was sufficient cause to condone the delay under such circumstances. So my responsible submission is the learned district has rightly rejected.
Very brief reply.
Now, all these reasons that my learned senior is putting forth, that we had prosecuted the other appeal, those are not part of the impugned judgment. These are additions being made here. Had the impugned judgment said so, then things would have been different. The impugned says 14 is not applicable, hence I will not look into the question of delay. That finding, I had shown that exact paragraph, that finding is contrary to a series of Supreme Court judgments and also the Privy Council judgment. That's the first patent illegality which probably they're trying to sidetrack that issue. The impugned judgment doesn't take note of these additional factors. If my learned senior wants to go into the details, I'll tell your lordships why they are shying away from merits. Because in the trial court judgment basically says that the defendant enters into the property by way of permission and thereafter the suit has been decreed on the basis of adverse possession.
But why will this court enter into the merits?
No, because once they say, suppose they rely on Isha Bhattacharya, it says that you look at substantial justice. Here, the reason, now my lord knows that first appeal is a very valuable right. It's the final court of facts. The first appeal could have corrected this. The judgment of the trial court on the face of it cannot be sustained. That's the reason why they are opposing limitation tooth and nail before your lordship.
You file it by way of a note, Mr. Barik.
My lord, I will.
Hearing concluded, judgment reserved. Parties may file their note of and memo of citations, if any, within a week. Note will be very short. Only bullet points. Mr. Mishra, you know the.
Yes. Grateful to you.
Item 2. That is parted, your lordship remember that section 15(2) of Hindu Succession Act.
He's requested for a passover for the day only. For day, day after tomorrow. Tomorrow or maybe on
2-3 days.
You're not available, sir.
We'll
take it up next week then.
You see, matter is almost.
He wanted to give us a short reply.
Let him be specifically say when it is convenient to him. Because I have some real difficulty, because your lordship put parted and want to complete it, I have come. For this purpose only I stayed. Anyhow, Miller.
Of the office of Mr. Prafullo Kumar.
Any day convenient to him, let him say that. That day we will argue the matter.
There's nobody here. None of his associates are here. So, sir, kindly wait for some time.
I don't know, 5. Item 5 minutes. The amendment may kindly be allowed.
Because as per to their amendment petition,
orders, item 5.
already appear on dated 9/2024 for Sepati Thakur and Amit.
कौन है आउथर कहले सुन पाले ना
Amendment
We are for
petition.
the appellant.
3 IR filed by the appellant, substitution, condemnation or delay.
That is all. Let us take-
Development. IR number 236, your lordship, may
Respondent
appear for
4E.
the respondent number 4E.
236, 237 and 238.
ହେଲା ପର୍ଯ୍ୟନ୍ତ substitution ପାଇଁ ସେ appear କରି ଯାଇଛନ୍ତି।
ଆପଣ you have already appeared.
ଏଇ appear କରିଛନ୍ତି,
ଆମେ
sir,
appear କରିଛୁ।
You are appeared. All right.
4E ପାଇଁ।
236, 237, 2 केते डिले अछि?
2 years nearly, 2.5 years.
2.5 years. Notice had been issued.
Yes.
Notice ରେ appear କରିଛନ୍ତି।
Your respond key मरी गेले respondent number 4E. 4E.
Niranjan Thakur.
These are applications, these are application for substitution of respondent number 4E. है ना? Notice having been issued in these matters, comma, the LRs of respondent number 4E have entered appearance. है ना? They have no objection. Where is your wakalatnama?
Because they already filed.
File matter.
Count.
That is on 9/8/2024.
Ajib hai.
Not दस्तखत कर
They have no objection to the prayer for substitution, for being substituted in place of respondent number 4E. Accordingly, the applications are allowed. Delete आगो condone कर दो, delay is condoned.
My lord, not
कौन पूछूं? Yes, yes. What do you want to?
One noting is there, my lord. As per to the order dated.
respondent number 3 not yet taken. Respondent
ଆଜ୍ଞା ସେଟା ବି ଯିବା ଏଇଟା ସରିଯାଉ ଗୋଟେ ଗୋଟେ ନହେଲେ କନଫ୍ୟୁଜିଂ ହବ allowed respondent the LRs of respondent number 4E as per
Base
Amit Thakur and Sashikanta Thakur.
Sepati Thakur and Amit Thakur.
as per the schedule be implemented as respondent number 4E bracket small I and 4E bracket IA. है ना? Copies of appeal memo be served upon them. Yes. तापर आगो कोटा कहले
noting रे अछि against respondent number 3 not yet taken.
Respondent number 3 have died during pendency of the appeal before the district judge, and that was respondent number 3 name is deleted by the learned appellate court.
So you deleted here.
Here, my lord,
Already.
also the cost title we have mentioned that it is deleted by order dated.
No, left
The
hand.
cost title
By order dated
6/4/2000 by the learned appellate.
6/4/2020.
So 2000 before filing of the second appeal.
6/4/2000 ରେ delete ହେଇଛି ବୋଲି order ରେ ଅଛି।
ଏଠି କୋଉ order ଟା ଅଛି?
Consolidated cost title respondent number 3 deleted in the order dated 6/4/2000।
ସେ consolidated cost title କାହିଁ? delete କଥା ତ ଲେଖା ହେଇନି।
ହଁ ଦେଖା ହେଇଛି।
ଆଶିଷ କୁମାର ଯୋଶୀ ତ କୋଉ ଲେଖା ହେଇନି?
ନା,
निधि प्रिया
निधि प्रिया जोशी।
Sir, consolidated cost title says Ashish Kumar Joshi.
Respondent number 3, my lord.
Here, respondent, sorry. Nidhi Priya Joshi. Okay, okay. Since died during pendency of the first appeal and her name was deleted as per order dated 6/4/2000 of the first appellate court, there is no need to substitute her before this court. Yes, ତାପରେ
ଆଇ ଗୋଟେ ଫାଇଲ କରିଛି ଫର ଇଞ୍ଜେକ୍ସନ ପାଇଁ ଇଞ୍ଜେକ୍ସନ ଆଇ 728/2024 ସେଥିରେ କପି ଆଜି ସର୍ଭ କରିଦେଇଛି ନେକ୍ସଟ କୁ ଆସୁ ଆଜ୍ଞା ହିୟରିଂ ପାଇଁ ଆଉ ପ୍ଲିଡିଂ କମ୍ପ୍ଲିଟେଡ
reading complete
मतलब let it come.
I এটা 2003 ର
ନା
RS
24 728
RS এটা 2003 ତ you can let copies of this IA be served upon
already
Already,
sir
acha copies of the IA has already been served upon the counsel appearing for the other side.
next
It is however stated at the bar that the matter is otherwise ready for final disposal. ଆଚ୍ଛା LCR ଆସିଛି?
ହଁ already ପାର୍ଟ ହେଇକି already ସରିଥିଲା ଆନନ୍ଦ ସାରଙ୍କ କୋର୍ଟ ରେ ସେଟା ତାପରେ ଅଛି
List this matter for hearing on In the week commencing 9th September.
ନା ଆଉ ଟିକେ ଜଲ୍ଦି ଆଇଟା ଫାଇଲ ହେଇଛି
ହବନି କାହିଁ ବେକାର କରି ଲାଭ 4 ଦିନ କୋର୍ଟ ଅଛି ଆର ୱିକ୍ ରେ ସବୁଠୁ ଭାବିକି କରିବାକୁ ପଡିବ ନା yes
Item number 6.
address is dead.
No, in fact, the report is wrong. He is early. And the respondent number 7 is the brother of appellant. And there, in the meantime, lords, long back, there has been severance of status between the parties.
Severance of life I think.
He has taken his share and he will settle in Palasa, Andhra Pradesh. So accordingly, I am filing a memo for deleting his name.
Yes, yes. Sri S.K. Pradhan, learned counsel appearing for the appellant, submits on instructions that respondent number 7 is not dead and therefore the the postal report showing him as dead is incorrect. He further submits that there being a severance of status between the appellant and respondent number 7,
Both are
comma, who is his brother, comma, the latter has been residing, the latter has settled down in Palasa in Andhra Pradesh. So, submits that the appellant does not seek any relief against respondent number 7 and as such his name may be deleted.
At his risk.
Yes,
সেটা কোন মুড অর্ডারটা রাখলে আমি রাখিনি considering the submission as above the name of respondent number 7 কি আছে কোনটা না
Enkate Ratrao.
এনকেটা রথ আচারি এটা দেখি লিখে দেব
Son of late D. Apara.
be deleted from the cause title at the risk of the appellant. Yes.
It is unserved on respondent number 8A, 8B, 9 and 10, my lord. Thereafter, this matter was listed on 1/10/2019. On that day, my lord, this a peremptory order was passed to take steps within 3 weeks, my lord. But it was not possible on the part of the appellant to take steps within that stipulated period of time. Therefore, this application for extension of time was filed. Thereafter, the appellant also took step so far as the respondent number 8A and 8B are concerned, my lord.
You want them to be deleted?
Yes, my lord, they are already 8A. The legal heirs of 8A are 8B and 8C. They are on record, my lord. Thereafter, my lord,
Respondent 9?
Respondent number 9 also they are on the legal heirs of.
So let us complete that. We'll delete it at your risk.
Yes, madam. They are on record.
All right. It is submitted that the LRs of respondent number 8 bracket small a and respondent number 9 are already on record.
Yes, madam.
And therefore no substitution is necessary. In such view of the matter, the names of respondent number 8A and respondent number 9 be deleted at the risk of the appellant.
Appellant, yes, madam.
Yes, then complete set of
Yes,
limitation upon 3, 6, 12A to 12G.
Yes,
Filed on ether regarding acceptance. 2019.
yes, madam.
As 2019 requisites कोण आवश्यक काम दो? You file fresh requisites. 2019 में ये 5 वर्ष होने से stamp value change ही है ना तो. Fresh requisites be filed. Yes.
9 भी मरिगलन 2 वर्ष होड़े.
Oh, fresh requisites be filed for issue of notice on limitation matter afresh upon respondent numbers 3, 6, 7, 12A to 12G by registered post fixing short returnable date. List gala. IA number 218, 216, 217 for condonation of delay. এটা তো সে setting aside of response sole appellant.
Yes, my lord. Sole appellant has died in the meantime, my lord. During the pendency of these
তারপরে IA
applications.
218, 216, 217. হ্যাঁ So we'll allow it?
I am served the copy.
Yes, I
Allow for it?
Yes, my lord. Just now.
When did he die?
My lord, on 26/1,
Yeah, এটা করেন ডিলেটা খালি কন্ডোন করতে হবে subject to payment of rupees 500 as cost, which shall be paid to the council for the, you know,
my lord, COVID, during COVID period, my lord.
COVID period. না আমার COVID পূর্ব 26/1
26 acres within the period of substitution.
allow করে দিন. Who are the LRs? কে
LRs,
মেনশন
my
হয়েছে
lord.
শিডিউল
Yes, my lord.
শিডিউল মেনশন হয়েছে তো
Yes, my lord.
অলরাইট allow. তারপরে 238, 237, 236 তারপরে রেসপন্ডেন্ট 8B.
Yes, my lord.
See, that is in 2012.
Yes, my lord. My lord, 2000.
এইথরে দেবে দেবে 1000 টাকা দেবে allowed subject to payment of rupees 1000 as cost to the, which shall be paid to the council, no ଆପଣ bar council,
yes.
bar association shall be paid to the bar association welfare fund and receipt be filed
Yes,
in the court. Respondent number 10 से 2015 14 और তাহলে 500 করে দিন দুইটা
Yes, sir.
দুইটা 5 করে দিন সেটারে 5 আর 3 5 করে দিন allowed করে দিন out condonation of delay. Yes, delay in filing of appeal.
A medical certificate she has also given.
Delay के दिन
Delay 5 years perhaps.
और मैटर कौन है देखिए
This is suit for partition. Share of having allotment was made. Therefore, challenging the same from to this order.
272 days delay will go. Not 5 years. What SR says it is 232 days. 272 days. This is regarding the appeal.
Appeal, yes, my lord.
13 to
Or 270.
3 ବର୍ଷ 2013 ରୁ 15 more than 2 years.
All right. Considering the submissions and the grounds raised, the delay in filing of the appeal is condoned, subject to payment of cost of rupees 1000, which shall be paid to the Orissa High Court Bar Association Welfare Fund Nagar. Sati?
Yes, ma'am.
I know respondent no 9B also died in meanwhile 2.5 years died. He has not filed any substitution.
देखिए जाने नहीं पर 9 तो अच्छी information.
हम तो
Steps for
order passed to
substitution.
1/10/19 we should but matter will be deemed to be dismissed as per direction of this honorable court.
Extension.
କିଛି ଅଲଗା ତ ମେ ନଏ ଛାନ କିଛି ଦେଲେ stay.
এই যে ଗୋଟେ ପିଟିସନ ପକେଇଥିଲେ ନା ପିଟିସନ
ନା ସେଟା knowledge ଥିଲା ଆମେ ଜାଣି ପାରୁନଥିଲୁ ଆମେ perhaps କିଛି ନେଇ ନାହାନ୍ତି list ରେ
ନାଇଁ ନାଇଁ ଗୋଟେ ପିଟିସନ is there since 2019 ଆଉ
ଆମେ କପି ଦେଇ ନାହାନ୍ତି we are blind.
ତାହେଲେ ସେଇଥିରେ ଇଏ କରନ୍ତୁ
ଆମେ କଣ କପି ପାଇଛୁ
we'll take it up for so you to steps for substitution of respondent number 9B be taken within 2 weeks.
Yes, ma'am.
Yes. Place this matter for admission in the week commencing 23rd September.
I don't know 9.
Lord, item 9. The Lordship kindly see your Lordship's order dated 7/12/2021. I am for the respondent. 7/12/2021. The respondent number 1 died and they did not take any step for substitution. So therefore appeal was abated against respondent number 1 and the order was passed for final hearing on 9th April. Thereafter, they filed 3 petitions for substitution of respondent number 1 without giving the name of all the legal heirs. But that application, we filed objection and this honorable court on
that on 13/5/2022 and giving them liberty to withdraw that application and file the better application. And they have filed this application for substitution. Now, let the substitution be allowed because in this case, my lord, in this appeal, my lord, this is against the confirming judgment. My lord. And my title over the property has been declared and we have decree for recovery of possession. In that property, they are running a petrol pump, my lord, and earning more than 2 lakhs per month. My lord. And this honorable court has directed for appointment of receiver also on our application and to submit the account. They did not submit the account. We have filed an application for discharge of the receivership. That application is pending, the subsequent interim application. In this context, in this situation, I am saying that the stay order is operating against us. Execution case has been stayed, they are not taking any step, not appearing.
Then we will not do we will do one thing. We will not pass any order today. Let it continue. If for the entire week they don't appear, then I will dismiss the appeal.
The second interim application for discharge of the receiver. From the receiver.
Pending था.
Yes.
नहीं से था pending था. पास और एक था. प्रत्येक दिन call out हो. तब देखिए last दिन देखिए.
I know 10.
10 my lord, on behalf of Mr. Ram, let us 2 weeks time, my lord, for taking steps of the regarding death of soulless man.
All right, 2 weeks time is allowed to take steps for substitution of sole respondent.
I may permit one more claim, my lord, out of the same, my lord, item 37, my lord.
No, wait.
My lord.
Item 11.
May please your lordship. That is for the noting, the 2 ayes are there, but I'm not pressing it, my lord. The appeal is ready for hearing. I pray that a date may be fixed on the next week or.
IA 196 or 52 अच्छी. They are not pressed.
Yes.
If the matter is otherwise ready for hearing, place this matter under the heading hearing in the week commencing
17th September.
17th September.
Sir, I am appearing for respondent number 1 to 3.
Till then, the interim order may continue.
Interim order to continue.
Yes.
I don't know 12.
3 bar. Oblige.
I don't know 12. Hearing date may be fixed.
Place this matter for hearing in the week commencing
17th September.
17th September.
Interim order to continue.
Interim order to continue.
Item number 13.
13 for condonation of delay, notice was also issued. And some of the opposite party also enter appearance.
The respondent number 2 has died.
Died, yes.
You have to take steps.
Sir.
2 weeks time is allowed to the appellant to take steps for substitution of respondent number 2, who is said to have died in the meantime. Who this 3, 8 and 10?
Who 3, 8 and 10.
No, 3, 8 and 10 खाली. Pressed steps be taken.
That's it.
Press notice be issued in the limitation matter on respondent number 3, 8 and 10 by registered post, fixing a short returnable date. The requisites be filed within 3 working days. तापरे 18 और back from the postal tracking टा देखिए. The postal tracking report shows that the notice on respondent number 4 was duly served. No. There is how somebody has appeared. So that's it. You carry out. Let's this matter October.
In the week commencing 21st October.
In the week commencing 21st October.
Yeah.
Item 14.
My lord, in the last date, notices were issued to the respondents who the other respondents.
No such address at the residence of Prasanth Aswam.
My lord.
Respondent 2 and 3 with the report, address he left.
My lord. We will take first steps, my lord.
Yes.
We will again, after instruction, will take first steps for responsible.
For whom? Respondent number 1 to 1 double I.
1
Roman 2.
Fresh notice be issued to respondent number 1, 3
3 to 9,
1, 9
my lords.
by registered post. Returnable within 4 weeks. Requisites be filed. And then issue 1, 4 will say 1, 9, respondents 1, 3 to 1, 9 and respondent number 2 and 3 by registered post. Fixing returnable within 4 weeks. Requisites be filed within 3 working days. Let this matter in the week commencing 7th October.
My lords.
Item 15.
In item 15, in the noting, it has come that respondent number 3 and 4 is the posted.
Since notice issued on respondent number 3 and 4 was refused, the same is treated as sufficient.
Yes.
It is not back from respondent number 5 and 6. Postal tracking report not available. Congratulations.
So we are going to take fresh steps again.
Yes.
Notice.
Fresh notice be issued to respondent number 5 and 6 by registered post. Fixing a short returnable date. Requisites be filed within 3 working days. Let this matter in the week commencing 37th October. 2nd October. Yes, 7th. 7th October.
I am appearing for the respondent number 1, 19 and 20, man.
Item 16. My lord, I have filed an application for exemption of court fee.
Yes.
Your lordship.
Your lordship had directed me to take the instruction from the CDMO on the disability certificate furnished by the appellant. I have not got it.
See, I asked AG requests for some time to comply with the previous order. Place this matter in the week commencing. Yes, shorted.
27th August.
27th August.
Sir.
The previous order be complied with positively.
Item 17.
Wait, please, my lord. My lord, in this case, I have filed.
Your lordship, there is a defect, there is a deficit of court fees, rupees 4.5.
File it in the registry. Defect be removed by tomorrow peremptorily. Yes.
My lord, another substitution we have filed, my lord, in this case. TIS has been filed, my lord. It is in the petition, my lord.
Just. Yes. Which matter?
My lord, item 17. Item 17.
Yes, 17, yes.
My lord, substitution I have filed respondent number 2 have died, my lord.
17 देखना बोला पड़ा.
My lord, ସେଥିରେ ଗୋଟେ deficit ବି ଥିଲା court fee 4.50 not yet been filed. My lord, ଆମେ file କରିଥିଲୁ କିନ୍ତୁ କିଛି ନାହିଁ ବୋଲି ଆମେ ଆଉଥରେ file କରୁଛୁ.
You file it by tomorrow peremptorily.
ଆଜ୍ଞା.
Yes. Next week.
Item 18.
It will come next week.
Item 18, it is exemption for court fee. I have filed an income certificate obtained from the competent authority. My lord has directed my learned friend to obtain instruction regarding the genuineness of this certificate. My friend could have obtained it from the website. Even today he can obtain it. My learned friend is not interested.
No, not that. In fact, from the authority I have sought for website account.
Income certificate
that you have supplied before the honorable court. Who says no?
I am appealing for the cabinet. I
Veracity
filed
of
objection
that.
to the income certificate.
All right. One more opportunity.
Pardon?
One more opportunity.
Sir.
As requested by Sri Ardas Karnade GA. 1 week time is allowed to comply with the previous order. This matter in the week commencing 27th August.
That interim order to continue.
Interim order to continue.
Mila.
Item 19.
Well, noting is that 4C and 6.
4C.
AD has not returned and the tracking report is not available.
Take fresh notice. How
notice? Sufficient.
Okay. Kim sufficient. नहीं जा तो better.
I'm appearing only 2A to C. 2A, B, C.
Fresh notice be issued to respondent number 4C and 6 by registered post fixing a short returnable date. Requisites be filed within 3 working days. List this matter in the week commencing 7th October.
Oblet.
Nuwa matter order.
Respondent.
Yes.
I'm for the respondent to A to C.
हाँ तो अब ना तो अच्छे हो.
Yes. Oblet.
Item 20.
This cycle. Chapter 12.
You are appealing.
I have appealed for respondent 3 and 5.
Sri D.P. Manthi, council appears for respondent number 4 to 6.
3 and 5, my lord.
3 and 5.
My lord.
3 and 5. And you?
My lord, I am for the plaintiff respondent number 1.
Respondent number 1. Respondent number 1 has already
Appeared on the date of admission. I was in caveat.
Okay, okay. Now, respondent number, the other, it is notice is sufficient. Postal tracking report reveals that notice on respondent number 4 to 6 is sufficient. Ki appear korna thi?
3 and 5.
In fact, my
4 to 6, 4 to 6. 3 and 5 holo, 4 bhi achi na? 4, 6, 4, 5.
permits I assist you, Lord. The dispute is between them and me. Others, though were the parties, my lord, they in fact will not get out of this anything.
So it is for the appellant to delete them at his risk. If he so wants, we can delete.
I will examine whether they are justified.
The notice the sufficient if they don't appear, they don't appear. Okay.
Interim order is there.
Well, that is the problem for me. Because after having suffered 2 decrees, at the admission stage, I was opposing. The lordship said that let it be there, we'll hear it. Well, that is the.
We'll hear it. We will hear it.
I am ready today even if my senior.
LCR Rashi. LCR.
LCR.
Acha, remind the court below to transmit the LCR at the earliest. Let's this matter go to short date court September.
Well, there is another second appeal.
In the week commencing
23rd September.
23rd September. Yes.
There are 2 second appeals. LCR. 167 and 180 of 2020.
They are connected.
Yes.
Yes. Connected he gets it.
Nice. It is 9.
So let this matter in the week commencing so and so along with RSA number
180 of 24.
180 of 2024.
My lord, LCR is in the section we have verified. LCR is in the section. We have verified. That's why I'm making that statement.
Tell have to short date kar de.
Well, can it be on 27th week?
No, 27th is already loaded.
All right.
This is a 2024 matter. That is what.
As you lot.
No, it is stated at the bar that the LCR is available in the connected appeal, being RSA number 180.
180 of 2024.
180 of 2024. Such being the case, let this matter in the week commencing 2nd September, along with the LCR. And along with RSA number 180 of 2024.
Interim order is there.
Interim order to continue.
Item 21.
There is delay of 448 days.
Notice पठेगा कौन करे?
My lord.
आइए कहते हैं 736.
Yes, ma'am.
Issue notice to the respondents. I think 3 and 4 you can appear.
It is,
3, 4 and 5.
Yes.
And 7 also. The 7 is separate.
Municipal corporation.
Sir, Olga Jibo.
Yes.
Acha. Sri Ardas Kannadi accepts notice on behalf of respondent number 3, 4 and 5. 3 extra copies of the petition be served upon him. Issue notice to respondent number 1, 6 and 7. 1, 2, 6 and 7 by registered post. Fixing short returnable date. Requisites be filed within 3 working days. List this matter. Yes, September last report.
30th September.
In the week commencing 30th September.
Mine.
Item number 22.
Heading does not
Monday.
Yes, item 22.
Item 22, may I pray on Friday, madam?
All right, pass over.
Item 23.
Item 23, Your Lordship, my senior Mr. P.K. Par is out of station. Your Lordship may keep it to tomorrow.
Pathak. Yeah, I mean, pass over.
Oblige, Your Lordship.
Item 24. Item 39.
24.
I'm sorry.
Item 24. 24 is your matter, Mr. Das.
Yes.
Couldn't?
Das is no more there. In that.
Okay.
Yes.
Man, Mr. Das is physically present, but not in the case.
All right.
We have filed one application under order 1 rule 10 in that matter, madam.
For improvement?
Yes, madam.
Where is that? There is no such application?
But it was, I think it was, yes, item 24.
24. Yes. IA 427 of 2020.
Right.
Anyway, this is for admission.
Yes.
So let us hear the admission.
Where the sisters of the plaintiff number 15 have not been implicated throughout the process matter in the suit as well as in the RFA. So we have filed applications for impediment of the parties matter.
Who were not impeded?
Sisters of plaintiff number 15 matter.
Let us see what is the appeal about. Yes.
I seek one matter pass over, Your Lordship, because this is an engaged matter. So I don't have power and
Power is not important.
Mr. Mishra is to do this in an engaged matter. One
Pass
matter
over.
pass over.
All right, pass on. He's coming.
Yes, yes.
All right.
Item 25.
There are 3, 4, 5 matters.
Four appeals, madam.
Four appeals.
Arising out of
Same judgment. All right.
there was suit counterclaim,
Counterclaim.
4 appeals and 4 settlements.
Well, item 25.
Your my lord, the first appeal was dismissed due to delay, my lord. So against that, I filed this appeal, my lord. The respondents are the plaintiffs and appellants are the defendant.
Respondents are the
Plaintiffs,
You are the defendant.
defendant.
Yes.
Plaintiffs filed a suit for partition.
Yes.
That suit was ex parte decreed. When the defendant came to know about the ex parte decree, he preferred an appeal before the lower appellate court. The delay of the filing appeal is 586 days, my lord. And the ground taken by the appellant in the lower appellate court that the advocate clerk of the conducting counsel was died when he was conducting the suit, my lord. The advocate clerk of the defendant.
Good.
The advocate.
I am smiling for another reason.
My lord. The advocate clerk.
Because in that area, in Bhadrak, Baleshwar, it is a Morir dominated bar.
My lord.
Yes, it is the Morirs who conduct cases. But I am not going to accept your no ground. That is no ground. Tell me how the finding is wrong.
If your lordships kindly see the aberments taken that has been mentioned in the order sheet, my lord. That is annexure 1, my lord, page 1, my lord. The impugned order, the impugned judgment, page 1, second paragraph. During course of hearing of the petition, the learned counsel for petitioners contend that appellant number 1 is an old and ailing lady.
Who is
my
page of the impugned judgment?
1, my lord. Appellate court judgment.
Appellate court judgment, so?
My lord, page 1.
Page 1 came to page 1 to constantly.
My lord, though I have not mentioned the page mark, but the
page 4.
Page 1, page 2, my lord.
Where is it mentioned?
My lord, during course of hearing, second paragraph, my lord.
Second paragraph, the plaintiffs who bhulta phuli china. Okay. 187 of 2018 to?
My lord.
Patita Baban Ponda?
My.
Full ठीक खुल रहा है।
नहीं दधी बावन जीव 25 दधी बावन
hey अपन 26 को बोले नहीं what about 25
I am placing the 25
टा आउ गोटे मैटर आज्ञा पतित बामन पंडा वर्सेस परीक्षित पंडा RSA 187 of 2018. The matter which you are referring to, that Dadhiva Manju, is to RSA 203 of 2019.
My lord, sorry, my lord. Sorry, my lord. I've so kindly taken up height
Good.
25.
25 pass over.
My lord.
Ethra koi chi?
In that case, in this case, that is item 26, my lord.
This is what you are, submitting now.
My
So appellate court judgment, yes. During course of hearing, yes.
My lord, during course of hearing of petition, the learned counsel for the petitioner contend that the appellant number 1 is an old and ailing lady. She depends on her only son. The petition number 2 of this case resides in Kolkata. It is further contend that after getting summon of case of original suit bearing number 47 2005, they appeared in the case through Mr. Golek Prasad Rai advocate. The advocate clerk Sashikanta Das was entrusted to look after the case. After his death, no appropriate step was taken by him, and subsequently, expertise judgment was passed in the original suit. After getting notice in the final decree proceeding, the petitioners appeared through the advocate Sri S. Mishra and Associates in CS number 47 of 2005. But the advocate did not give any advice to them to file a case for setting aside the judgment and decree in CS number 47 of 2005. When the respondent number 4 attempt to plot the disputed land on 23/2017, at that time the petitioners came to know about such expiry decree and passed by the learned court below in respect of their properties in such premises. They my lord. So that is the ground, my lord, because the advocate clerk was looking after the case. So when she died, my lord, then the advocate could not conduct the case, and subsequently the expiry decree was passed. In the final decree, when he get notice and entrusted another advocate, then he found that the suit for partition was preliminary decreed. So after knowing that, he filed an appeal. And this is a suit for partition, my lord.
No, you have been allotted some share.
My lord, I have a share, but he allotted more share than he is entitled.
Oh, Korea. Korea.
My lord, because if your lordships kindly see the
I was just looking at your ground. There is nothing. Advocate clerk ଥିଲେ ସେ ମରିଗଲେ ତେଣୁ ସେ ଆଉ କିଛି କଲେନି ଆମେ ଜାଣିପାରିଲୁନି ସେ ଯେତେବେଳେ ଆସି ଚାଷ କଲେ ସେତେବେଳେ ଆମେ ଜାଣିଲୁ ଫାଇନାଲ ଡିଗ୍ରୀ ପ୍ରୋସିଡିଂ ସେତେବେଳେ ହେଇଗଲାଣି
final degree, my lord. In final degree, I came to.
ହବନି.
Can I pray for some more time?
Why? My mind will change.
No, my lord, no.
Yes.
For my satisfaction.
What satisfaction? I am willing to grant you the entire day. You argue. Convince me. Yes, you can convince me. Seମିତି କିଛି rigidity ନାହିଁ. If you come up with a ବର୍ତ୍ତମାନ ଯୋଉ point ଟା କହୁଛନ୍ତି ସେ point I am not convinced.
For because I have not with the appeal memo along with the limitation application. So for that reason, I will be.
କାଲି କଣ?
My lord, day after tomorrow.
Pass over. Day after tomorrow ଲେଖିଦିଅନ୍ତୁ.
My lord.
Item 27.
Yes, 27.
May I please your lordship. My lord, this is a reversing judgment, my lord. This is a reversing judgment, my lord. The
you are the
present appellant was the plaintiff, and the respondent was the defendant, my lord. Plaintiff filed the suit for partition.
Suit was decreed.
Suit was decreed, my lord, ascertaining 1/3 share each, my. But against that, the defendant preferred an appeal,
yes,
and the lower appellate court ascertaining, modifying the share, my lord, ascertaining half share on the basis of parcha, my lord.
What is wrong in it?
My lord, my humble submission before lordships, my lord. In Sabokarwar, the name of the 3 shareholder was recorded. Similarly, in the Hal Arwar, the same 3 shareholder recorded. But the lower appellate court stated that though in Parcha, the genealogy is mentioned, so the Parcha is more presumptive value than the Hal ROR. My humble submission before your lordships, during Hal settlement operation, Parcha was published. If any filed any objection against the Parcha, then subsequently the Parcha was cancelled, then Hal ROR was published. So when the
What is a Parcha?
my lord, that is the draft ROR.
So when the final ROR has been published,
My lord.
so obviously this
Draft
has no value.
No value.
Say that.
Only on that point I filed this appeal.
There is a substantial question of law. Heard Sri, you are Mr. Naik? Mr. SK Naik?
SSK Naik.
SSK Naik? ପୁରା ନାଁଟା କଣ?
ସୁଶ୍ରୀ ସୁନୀଲ କାନ୍ତ ନାୟକ।
ଆଜ୍ଞା?
ସୁଶ୍ରୀ ସୁନୀଲ କାନ୍ତ ନାୟକ।
ଆପଣଙ୍କ ନାଁ?
ଆଜ୍ଞା।
ସୁଶ୍ରୀ?
ଆଜ୍ଞା।
What is there in a name after all?
Because,
isn't it? A rose called by any other name would smell just as sweet. William Wordsworth. No, William Shakespeare. I think it would be William Shakespeare. I'm forgetting. Heard Sri SSK Naik, learned counsel for the appellant. Appellant or appellants?
My lord, appellant.
Appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the first appellate court was correct in modifying the share of the plaintiff basing on the Parcha marked Exhibit D which is contrary to the final ROR published in the settlement operations. See, Gotakar Korea?
Only that.
Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter. Call for the LCR. List this matter. Actually, LCR work nahi to tha. Call for the LCR. List this matter on
30th September.
October.
21st October.
The week commencing 21st October.
Oh, bless you. My lord, there is a
IA. Final decree to?
Final decree.
All right. IA likhi do. The final decree proceeding shall continue, but the decree shall not be sealed or signed without sealed or signed till the next date.
Oh, bless you.
Item 28.
Pass over.
Item 29.
Item 29 minute, the notice has gone, while the respondent is appearing minute.
Somebody is appearing. Who is appearing?
So because
Biruja Prasad, yes, he is there.
The respondent number 1.
Yes. Notice was issued.
Limitation ground.
Oh, limitation.
Yes,
That is what I am saying.
has been condoned and also.
Bill has been condoned.
Yes,
my lord. He has paid all the
1,000 have paid, the legend condoned.
Sri BP Das, standard counsel appearing for the respondent, submits that he has received the cost of ₹1,000 directed to be paid by this court. Admission?
Yes, madam. Yeah, madam, it's a reversing judgment, my lord. The suit was filed by that is the respondent number, my lord, 1. The suit are dismissed.
Suit for?
Suit for, my lord, declaring the sale deed to be, my lord, null and void, my lord. And according to suit was dismissed and he went on appeal. Appellate court, my lord, by judgment dated and reversed the order of the civil court's senior division.
On what ground?
And that ground that my lord has taken. I don't have copy of the appeal memo, the judgment, my lord.
Copy of the judgment will not transfer brief, so there are three substantial questions of law that is framed. The co-sharer is not a party to the suit, my lord. The non-jointer party, the suit is not maintainable. First thing, my lord. And second thing, my lord, there is no partition between the parties with mesh and bounds, my lord. So he's claiming share over the property. That property has not been partitioned by mesh and bounds, my lord. So plaintiff's claim over the property that since there is no partition between the parties, also cannot claim about this that particular the plot in the suit in question, my lord. And third thing, my lord, partition between the parties, my lord, there is no shell deed, my lord. Only she is claiming that I am in possession of the suit land since long, and for which the deed was filed.
What is the substantial question?
And the illustration can count, my lord, that is at page, my lord, page 13 of the memo, my lord. The paragraph D. Whether the recital of the shell deed with regard to the prior partitions and the vendors joint holding in the conclusive proof of partition or mesh and bounds in absence of any other evidence to that effect. And ground number E. Whether all the owner co-sharer of the joint holding are necessary or proper parties to the suit when he claims it in the respect of the person of thereof, and the plaintiff's suit is bad for non-jointer parties and so on. Ground number, that is
Holding by one co-sharer
yes,
is
claiming about the yes.
he holds it on behalf of other co-sharers
Yes,
also.
madam.
Before the suit land is partitioned by meets and bounds.
Yes, madam.
So his holding is not his exclusive holding, but it must be treated as on behalf of other co-sharers also.
Yes, madam.
In such event, I don't think non-impletion of non-jointer of parties would have
Suit, my lord.
But
And also that ground number A, B, and C, my lord, whether the relief of the declaration of title on the basis of the shell deed, where exhibit 1 and 2 is available to the plaintiff on the since in respect to the specific portion of land of the joint sold, there is no partition with that the my lord.
well, I'll admit it on A.
My lord.
A will cover.
They will cover.
All right. Heard Sri B.B. Rautra, and counsel to the appellate. There is the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. এটা আছে page 12 A capital A. Well, issue notice যা করে রাখা পারবে call for the LCR. Place this matter. 7th October. In the week commencing 7th October. Since notice of can give
I have entered already appearance. He has to give
no notice need to be issued to the respondents as they have already entered appearance through Sri BP Das, on whom copy of the appeal memo will be served. Yes, Mr. Rautre. Serve a copy.
Other respondents are there. So many respondents. He has to take notice.
No, that is
Because for respondent 1, I have entered appearance.
there are other matter respondent that is
So let us see then how was the delay condoned.
That time I remember, my lord, your lordship has called for that the appellant, a personal appearance.
and that is the issue that how to delay.
That issue related to transfer of leave.
You are appearing Bahadur law, na?
The notice was not issued to others.
I entered my appearance on 27th October 2022.
That is, my lord.
Prior to that, my lord, notice on limitation provision was issued.
Respondent number, my lord.
No.
578, that
Notice on respondent number 3 to 17 is dispensed with for the time being, they being co-defendants.
Yes, madam.
That was dispensed with.
Yes, madam.
Not necessary.
Not
Only,
necessary, yes.
So,
I am the only contesting.
Respondent.
so no notice need be issued.
Yeah.
Correct. No notice need be issued to the contesting respondents since they have already entered appearance through Sri BP Das. On whom copies of the appeal memo will be served. Place this matter in the week commencing 7th October. LCR করা হয়েছে তো?
LCR
Miscase for that is there, so.
This case को
Status quo.
well, status quo with regard to the suit property shall be maintained till the next date.
Item 30.
My lord, I may be permitted to place on behalf of Jagannath Bhuyam.
Yes.
My lord, one IA has been filed for extension of interim order, my lord. IA number 870 of 2024, my lord.
Another IA has been filed for vacation of interim order.
I have also served copy upon the.
This has not been admitted.
Not admitted.
Let us see what is the one admission or कौन
My lord, I don't have any knowledge about the merit of the case.
कौन करिए
For person, for
merit
person.
merit is कौन थिले मुझे ताको से जो आपनकर interim order extension करेगी कि बात
Then it may be laid down for tomorrow.
yes pass on
Speak not just because Mr. Mishra, elder brother has been expelled. He has gone to
all then according to list this matter next week.
Item 30.
Huh?
Item 30.
हाँ छोटा बोला है फ्रांसिस
My lord, interim order, my lord.
interim order to continue.
Item 31.
Specific date may be
Weekly list yes. Item 31. All right, pass on.
32.
May be lord.
To deposit code fee.
Has already been paid, so I may be disturbed.
IA is dismissed as infructuous as the deposit code fee has already been paid in the meantime.
Here is a peculiar case, my lord. The plaintiffs are appellants in a confirming judgment.
Yes.
Well, in the suit for declaration that the salary under Exhibit 4 is void, my lord. It is not sale, it is for mortgage. During after notice in the suit, defendant did not file any documents nor exhibited any documents. In expertise, the suit was dismissed. Before pronouncement of dismissal of the suit, kindly come to my note page 4, para 4. And para 4.
Yes.
That by order 25/1/2004, the defendants were set expert, and in the suit, the plaintiff adduced 3 witnesses and exhibited documents. If you exhibit 7 or 13, in nua document exhibited 19, 60, 21. 1 ରୁ 6 କିନ୍ତୁ ଜଜମେଣ୍ଟ ସାର୍ ଦେଖନ୍ତୁ କେବଳ 1 ରୁ 6 ଲେଖା ହେଇଛି ତାର ଠିକ 2 ମାସ ପରେ ଜଜମେଣ୍ଟ ହେଲା ସେଠି ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟକୁ ଆସନ୍ତୁ ଜଜମେଣ୍ଟର ଲାଷ୍ଟ ପେଜ 29 witness on behalf of defendants need documents on behalf of plaintiffs exhibit 1 to that is the only substantive procedure.
No, this is the judgment of the trial court.
Again.
What about the appellate court?
Appellate court did not did not consider that aspect. That exhibit 7 to 13 were the documents exhibited before pronouncement of trial court judgment, but that part has not been.
All right.
My substantial questions of law at page 9, my lord.
Is C रे बताओ.
B ର ABC ଦିଆହେଇଛି.
नहीं, B ର C ଟା.
B ର C ଆଉ D. ଯଦି ଜଣେ WS ଦେଲାନି କୌଣସି ମୋ ଡକ୍ୟୁମେଣ୍ଟ ପଠାଇ ଏ C ଆଉ D.
Head Sri Maheshwar Mathil and counsel to the appellant. Appears the improved judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law. Page 9 ର C ଆଉ D. Whether the courts below were correct in completely ignoring the documents admitted into evidence as Exhibit 7 to Exhibit 13 prior to passing of the judgment.
Trial court.
Hala, eta C hala. D re, whether the courts below erred in law in considering the case of the plaintiffs under the provision of Order 8, Rule 5, bracket 4 of CP. Issue notice.
Sir, during pendency of the appeal, what happened? I have filed an IA. My office copy I am handing over. There are two lots. Lot number 1 and lot number 2. Kindly see the judgment. In respect of lot number 1, the trial court judgment declared achi lot number 1 and 2. The lot number 1 opere exhibit 6 sir jota consider kaleni exhibit 6 ଆଉ 7 ସେ ଆମକୁ ଗୋଟେ ଏଲେ ନୋଟିସ୍ ଦେଇଛନ୍ତି ଯୋଉଥିରେ appellant number 2 ନାଁଟା କଟି ଯାଇଛି ବର୍ତ୍ତମାନ lot number 1 ସମ୍ପତ୍ତି ଉପରେ ସେମାନେ ଚାହୁଁଛନ୍ତି ଏଲେ କେସଟା ପେଣ୍ଡିଂ ଅଛି ବର୍ତ୍ତମାନ defendant 1 respondent 1 ଯେ ସିଏ ତା ନାଁଟା ଯେହେତୁ ଏଣ୍ଟ୍ରି କରିଦେଇଛି in the settlement ସେ ଚାହୁଁଛି ବର୍ତ୍ତମାନ ସେ ଟଙ୍କାଟା ଦେଇ some protection may be given. I have given the suit land in the IA.
Where is that IA? Where is that IA?
এটা ମୁଁ ଫାଇଲ କରିଛି ନମ୍ବର ପଡିଛି ଅଫିସ ରୁପଟା ଦେଇଛି ନମ୍ବର ବି ପଡିଛି
ଏଟା ଆଜି ମଗେଇଦେ ହେଲା
ଆଜ୍ଞା
କଣ ଲେଖିଲେ ଇସୁ ନୋଟିସ୍ ଲେଖିଲେ ତ ଇସୁ ନୋଟିସ୍ to the respondents by registered post returnable within 4 weeks, requisites be filed within 3 working days. Call for the LCR. Release this matter in the week commencing November.
11th November.
11th November. IA, notice as above. Accept one set of process fee. In the meantime, in the interim, it is directed that, as an interim measure, it is directed that the award amount in LA case number 5 of 2023 of the court of LAO cum Tahsildar Soro shall not be disbursed in favor of any person.
Maybe deposited in fee deposit.
Shall not be disbursed. Shall not be disbursed in favor of any person till the next date.
Item 33.
Please, your lordship. My lord, the defendant is the appellant in the reverse with the confirming judgment. And the suit for 25 suit for specific purpose of content. Pursuant to the summons, my lord, the defendant appeared. The original defendant appeared and filed written statement denying the claim of the plaintiff and stated that the exhibit 1, stating that the honest agreement is not valid, lawful, and it is admitted forged for the purpose of the case. Thereafter, my lord, during the trial, when the plaintiff was filed his evidence on affidavit, only one line prosecution was made by the counsel for the defendant, and then he left the case. And ultimately, the trial court passed the decree in favor of the plaintiff without any contest. Only written statement was filed. And the appeal was filed. Appeal was filed, my lord, by the original defendant, but subsequently died. When he died, the present appellant filed an application under Order 22 Rule 10 to be implemented party on the ground that during the pendency of the suit, I have purchased the suit land. And the learned discharge rejected the same. Thereafter, the present appellant came to this honorable court, and this honorable found that he is a necessary party. He will contest the case. And thereafter, the matter was remanded, and the appeal, it was hard. And my argument before my lord, that is the exhibit 1. The exhibit 1 is the honest agreement. Your lordship, kindly see. I have annexed to my second memorandum of appeal, annexure 1. Your lordship, kindly see. This is an honest agreement, and in this case, in this agreement, your lordship kindly find the name of the vending vendor, my lord, second party.
Lokanath Das.
Lokanath Das. Only the signature, unless signature of Lokanath Das, but the Samir Kaur Patnaik, which beneficiary, who is the plaintiff, and in whose favor the agreement was executed, he has not signed, and no scribe has not scribe has not signed. No, it was not, your lordship kindly see, and no certificate was appended. No certificate was appended. Thereafter, your lordship kindly see.
ଅଛି ଲୋକନାଥ ଦାସ ଦାସରେ ଲେଖା ହେଇଛି
ଲୋକନାଥ ଦାସ ଦେଖିଦୁ ଲୋକନାଥ ଦାସ ଖାଲି ସେ ସମୀର ପଟ୍ଟନାୟକ ଦସ୍ତଖତ କରୁନାହାନ୍ତି କି ସ୍କ୍ରାଇବ ବି ଦସ୍ତଖତ କରୁନାହାନ୍ତି ତାପରେ your lordship kindly see the ଲୋକନାଥ ଦାସ the signature page 78 page 78 annexure 1 annexure 1 page 78
yes
ଲୋକନାଥ ଦାସ your lordship kindly ଓଡ଼ିଆରେ କେମିତି ଲେଖିଛି ତା ତଳେ ଇଂଲିଶ ର ପଢିଛି ଡେଟ୍ ପଢିଛି ତାପରେ ନେକ୍ସଟ ପେଜ ରେ ବି 78 ରେ 80 page re Lokanath Das. This is the disputed signature, my lord. I say that it is a manufacture and file written statement. Your lordship kindly see the admitted signature, which I file Bhogalatnama by engaging lawyers in IA and also the suit. But my lord, kindly see page 84 and 85. Page 84 and 85. It is the naked eye. This is the Lokanath Das, the signature of Lokanath Das here and the signature of Lokanath Das in Exhibit 1, the Annexure 1. Yeah. The court is the expert of expert, my lord. In the naked eye, it can be examined, it can be seen whether prima facie it is correct or not. Apart from that, the scribe of the document, scribe has not executed the document, has not signed. The party, the beneficiary, the plaintiff, in whose paper document he has not signed, my lord, and even your lordship kindly see the attesting out of two witnesses. One witness, though one Chandramani Bari was not examined, but Napo Chandra Sahu who was examined, his identity is doubtful. Nowhere his address is given in the Exhibit 1. Your lordship kindly see, and law is clear, my lord. I am just. Section 2(1) it's proposal, offer and statement of intention. The proposal when accepted gives rise to an agreement. It is at this stage that the agreement is reduced into writing and a formal document is executed on which parties affix their signature or thumb impression so as to be bound by these terms of the agreement set out in that agreement. Parties are bound by the agreement, the terms and conditions. In this case, parties have not signed. Only one party has signed.
So he rejects your appeal.
Yes, my lord. And apart from that, this is an understood agreement. Possession has been delivered. When the possession has been delivered, my lord, and in that case, it should be a registered document. My lord, as per section 1A, 17(1)(a), the document containing contracts to transfer for consideration any immovable property for the purpose of section 53A of the TP Act shall be registered if they have been executed on or after the commencement of the registration and other related laws, Amendment Act 2001, and if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of this section 53A, which is the law. My substantial law. I formulated the substantial procedural law, formulated.
No, Mr. Patnaik, I think we'll do it on A. Anyway, see you type on 17A katha 1A kata kodi koichindi. Have you referred to the 17(1) capital A of the Registration Act, that amendment?
17(1)(a). Yes.
No, have you taken that as a substance?
That please.
Kete seta?
Sir. बहुत जगह लिखो गोटे देखो
नहीं आपन सब्सटेंशियल क्वेश्चन
नहीं सब कहछि माय लॉर्ड जस्ट देखे सेउडा देखे जे ता तापरे जे
will do J then
J माय लॉर्ड आउट अछि ई ता अछि से जो प्रपोजल और ऑफर स्टेटमेंट जोटा कहली जोटा दस्खत करना थी पार्टी और एग्जाम कर E, ground number E and ground number J, man.
Yes. Sri Sashikanta Patnaik, Learned Counsel for the Appellate. There is the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. C.
J.
ଇଟା ହେଲା ପେଜ 19 ଅଛି
C ବି ଯିବ ସେଇ C D ସବୁ ଯିବ
ତାପରେ
ସେଇ exit 1 ଉପରେ ସବୁ ଲିଖିଛି
ଯେଟା କରନ୍ତୁ ଯେଟା ହେଇଗଲେ ଯେ ରେ ସବୁ କଭର ହେଇଛି
J ରେ ହବ E ରେ ହବ
ଇ ଆଣ୍ଡ ଜେ
E and J E and J
issue notice to the respondents ଯାହା କରିବେ notice ଟା କରିଦିଅନ୍ତୁ call for the LCR list this matter in the week commencing 11th November
people who like
item 34
Lordship, one possible for the day.
Item 35.
pass over
Item 36.
pass over
Item 37.
Any other bench? Any other bench?
list this matter before any other bench with kind permission of Honorable the Chief Justice as I am concerned. So I think, huh? For you. Hearing. Anybody ready? Pass over matters. Yes, Mr. Bose, your matter has come right. Oh, you know.
My senior, Mr. Bhoya, is there in that.
That matter, I think Mr. SP Mishra is to appear.
Yes.
Another court.
My senior will.
Should I pass it over for the day?
Let's say Rodin. I'll do the Rodin. Aro ikra asu sab.
Today item kete?
Set item 24.
24. So we'll take it up. List this matter.
The week commencing 27th August.
In the week commencing 27th August.
Yes, sir.
And sir, your matter.
Item 2, Miller.
Yes.
The name may kindly be reflected and the matter may come next week.
You are not available tomorrow, sir? Item 2.
Week commencing 20th month.
The name of Sri C.A. Rao, Learned Senior Counsel will be reflected in the
My
cause
name
list.
may
That is what I'm saying.
In item
List this matter in the week commencing 20th August.
Item 13 and my learned senior is there. Let it be taken up on Friday manner.
Awesome.
But Friday, it will be sir, next week as well.
Okay, like 37.
39.
38 रखिए देखिए 39 तक को कर दियो next week. 38.
38 response. Apatra had requested me
for Passover.
No, for adjournment because he was not well. Next week,
2003 matter.
Respondent by request.
All right. Next week. We commencing 20th. Item 40.
Item 40, the defendant had the appellant before your lordship. It's against the reversing judgment. Now, the lordship says the appeal was admitted, my lords, on.
My lord, item 40, seek for a passover.
Our problem here is that substitutions are repeatedly taking place. The last occasion also they took time. The lordship may hear me. It's against a reversing judgment on 3/2/2006. That was almost 18 years back. The appeal was admitted on these grounds. First ground is whether the consolidation ROR under Exhibit 1 could have been relied upon by the learned lower appellate court when the consolidation scheme had been subsequently cancelled under Section 5 of the Consolidation Act, much prior to the final publication under Section 41 of the Consolidation Act.
When do you say it was admitted?
3/2/2006. That is what our order shows.
Oh, it has not been written.
I'm at
Substantial question of law under paragraph J 1, 2, 4, and 5. Anyway.
The questions have not been reflected in the order sheet.
You can start. You can begin.
That
Don't
is
worry.
something.
I'm not completing
I
it.
bow down to what your lordship says. That is something which now the Supreme Court says that this
No,
cannot.
we are always therefore framing it. Maybe we are sometimes in very rare cases we are copying it verbatim, but in most cases I am framing it.
Now they have. So this can.
You can take note. We'll continue also tomorrow. Let him begin. Next time, let him begin.
My lord, may I formulate the question today itself so that he can reply. This question is sufficient.
J 1, 2, 4, and 5 ର ଯାହା question ଅଛି
সেটা অর্ডার শিটে হিয়ারিং বেলକୁ লিখিদেব হিয়ারিং যেତେବେଳେ কনক্লুড হবো সেটা লিখিদেব Yes, Mr. Begin.
Now, my lords, may kindly see J1, the first question, that has been answered by two judgments of this court. Here, in 1978, the consolidation scheme was there. Thereafter, it was cancelled, my lords, in 1991.
Let me just understand whether the consolidation error and exhibit 1 could have been relied upon by the level. Acha.
So this first question has been answered by two judgments of this court. I'll show them. So here, originally, in 1978, the scheme came about. And then in 1991, the entire scheme was cancelled. The question is that if there is a consolidation ROR in favor of the plaintiff, which came into being during this, in fact, it came into being in 1992. So whether that can be relied upon by the lower appellate. Trial court decided in our favor, saying that since it has been cancelled, you cannot look at it. Lower appellate court took a view that no, since consolidation scheme has come about, I will go by that, and that is how the suit was decreed.
Let us go to the trial court judgment for a moment. What was the suit for?
Suit, my lords.
You are the.
I am for the defendant.
Govardhan Khamari.
Govardhan Khamari.
Then what happened?
Suit was for declaration of right, title, and interest and confirmation of possession over Schedule A land with the damaged house and in the alternative for recovery of possession.
There's no LCR, Mr. Mishra. That's a problem. LCR achi dekhlo. And the problem is, I don't want to hard file to the
The LCR was, this appeal was admitted, so I'm not sure how the LCR has not come. Even on 3/2/2006, LCR was called for.
It may have come, it may have been digitized and the originals were returned in all cases. That when Honorable Justice Muralidhar was the Chief Justice, he took up upon himself that we should return all the LCRs.
If in one such case, which is an old case, the digitization itself is now no longer visible. So they are calling for the original. I doubt whether the original is available some. Otherwise, it will be difficult.
Here, what I find is the trial court judgment itself has not been scanned. Only the first page, the cause title page is there, and the remaining pages are not there, which of course may be there in the physical file. The scanning boys, they do not understand the ramifications of what they are doing.
But at least, my lords, since it's a reversing judgment, can I request that these questions may be formulated?
Yeah,
today?
that we will do that. Today we will do that, and I will call for the LCR. But nahi, nahi? Achi? LCR achi thi? Very good. তাহলে এক্ষেত্রে আমি হিয়ারিং করলা বেলকু যদিন হিয়ারিং ক্লোজ হবে সেদিন ফ্রেম করে দেবো because today I'm not going to.
Seita again, Mukhali, just to assist your lordship. Now, recently, the Supreme Court says that your lordship has to formulate on one date and give another date to him to reply. If it happens in this, I'm just trying to bring it to your lordship.
No, very good. I didn't know that.
If it is happening on the same day, that also they are finding.
All right. I didn't know that. We'll do. I'm not supposed to know everything.
No, my lords, I'll give that judgment to your lordship. It's a recent judgment.
All right, we'll J kete kaun J1.
J1.
Better appreciation.
4 or 5.
For better appreciation, the substantial questions of law framed, white order dated
3/2/2006
3/2/2006 are reformulated as follows. Koriki, kete koi den.
J1 to 4 or 5.
4 or 5 of page 8 of the appeal member. Release this matter tomorrow for hearing.
এই কেসটা মানে ମୁଁ ଏଥିରେ ଅଛି এটা ଟିକେ ନେକ୍ସଟ ୱିକ୍ ର ମୁଁ ଫାଇଲଟା କାଇଁ ଟ୍ରେସ୍ କରିପାରିବି ଆଜ୍ଞା ନା ଆଇ ହାଭ୍ ବିନ୍ ହଁ 40 ରେ ଆଇ ହାଭ୍ ବିନ୍ ଏନଗେଜ୍
Alright,
ଟିକେ ଏଟା
alright. Release this matter in the week commencing 20th August. Okay. We'll set up. 20th August will take up.
ସେ କ୍ୱେଶ୍ଚିନ୍ ଗୁଡା
ଫର୍ମୁଲେଟ୍
Yes?
ଏଇଟା ଟିକେ ଦରକାର ଫର୍ମୁଲେସନ
କରିଦେଲି ପରେ ଫର୍ମୁଲେଟ୍ କରିଦେଲି লিখনা ଯାହା ହେଇଥିଲା ସେଟା ଖାଲି ଫର୍ମୁଲେଟ୍ କରିଦେଲି ଆଉ
ଆଜ୍ଞା
interim order to continue.
Interim order to continue. Yes.
ମାନେ ଏଟା କେବେ ଫିକ୍ସ କଲି
We next week.
ଆଜ୍ଞା
ଗୋଟେ
Item 41, name of my learned senior may be kept because probably might have missed the list.
আচ্ছা ওটা পূর্ব লেখন্তু ଗୋଟେ the name of Sri Samir Kumar Mishra and senior counsel appearing for the respondents be indicated in the cause list.
ଏଇଟା 27 ୱିକ୍ କୁ ଟିକେ ରହିବ
ଆପଣ ନିଜେ କହିଲେ ନେକ୍ସଟ ୱିକ୍ ରହିବ ବୋଲି
ଟିକେ ଦି ତିନିଟା ପାଠ ଅଛି ତ ସେଠି ଅସୁବିଧା ହବ
ଏଇଟା ବି ପାଠ ବୋଲି ଧରିନି
ଆପଣ କଲେ ମୁଁ ଆସିବାକୁ ବାଧ୍ୟ କିନ୍ତୁ
My only problem is that these people have made 2-3 substitution.
ନା ମୁଁ ଚାହୁଁନି ସେଟା ସରିବାକୁ ମୁଁ ଚାହୁଁଛି
week commencing 27th August.
ଆଜ୍ଞା ମୁଁ ଚାହୁଁନି ଦୂର
ଆପଣ you are appearing for all the respondents.
ମାନେ ସେ ଟିକେ ଷ୍ଟେଟମେଣ୍ଟଟା ଦେଇପାରୁନି ଦେଖିଦେବି ଫାଇଦା ଆଣିବି
Item 41. Next week था आया माने almost 20 years ହେଇଗଲାଣି
27 ଦିନ କିଛି ହବନି ଗୋଟେ କରିଦବା 27 ରେ ମୁଁ ତ ଟାଇମ ନିଏନି କୋଉ କେସରେ ଟାଇମ
ନାଇଁ ନାଇଁ କିଏ କହୁଛି କି ଆପଣ ଟାଇମ ନିଅନ୍ତୁ କି who is saying that? No, who is saying that you are always taking time? Who is saying that? Yes, channel 41. 41. Next matter. Item 41.
This is just because Mr. Mishra wants to take time, but this is a matter like this. He suit for partition, confirming his judgment. Defendant is the appellate. She got 50% share naturally because the claim. During the pendency of the appeal, in fact, certain property has been sell deed has been executed by the plaintiff for third parties. Registered sell deed. Those sell deeds somehow could not be produced because they were not within the notice of the defendant number 1 to produce it before the lower appellate court. Now, during the pendency of the second appeal, I filed an application order for Rule 27 for additional evidence, enclosing those registered sell deed also. Of course, no objection has been filed for the additional evidence. That will be referred to at the time of hearing. That will be considered. That is also the order. Now, what I suggest, if those property will be excluded, whatever the share, 50% share, that is more than the share they have already sold. So, my client, in fact, suggested that if they will agree that matter can be settled, there will be no problem. Provided they will take.
If you agree, I can send it to mediation also. It's a partition matter after all.
Yes,
it can be sent to mediation.
That can be done, my lord.
Yes.
This can be done, my lord.
Then I can send it to a High Court Mediation Center.
Yes.
All right.
Yes, you also do it.
In course of hearing, it is stated at the bar that the matter having arisen out of a suit for partition and there having been some alienation of the suit property in the meantime, the dispute can be attempted to be resolved through the process of mediation. In such view of the matter, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful.
Can you also fix up a time limit because
the parties are directed to act upon receipt of notice from the mediator and to render full cooperation in the mediation proceeding. List this matter. I'll fix 1 month. 1 month.
Yes.
1 month per record.
We commencing 30th September.
We commencing 30th September because the mediation center is very busy now. 30th September. 30th September with the matter. Obligations.
if the mediation will fail, then it will be listed.
Then automatic that will list. I have directed it to be listed. In the meantime,
30th September. Also
30th September week in the week commencing 30th September.
Right.
बाकी तो कल देखेंगे.
Thank you.